Speaker.
Announcements.
Yes, Honourable Prime Minister. Obituary.
Madam Speaker, we have learnt of the demise of Mr. Ismail Hassan Jinawu, former member of the Legislative Assembly, on Tuesday, the 25th of November of this year at the age of 86. In 1983, Mr. Nawu contested the general election under the banner of the alliance MSM Travails in constituency number 3, Port-Louis-Maritime and Port-Louis, but he was not elected. He was, however, allocated a seat under the best with the system to serve the then Legislative Assembly. In 1984, Mr. Nawu was appointed as member to serve the Select Committee on Drug Addiction. He had some problems later regarding this issue. Madam Speaker, may I kindly request you to direct the Clerk of the National Assembly to convey the condolences of the Assembly to the members of the bereaved family of late Mr. Nawu. Thank you.
Thank you. Honourable Leader of the Opposition.
Thank you, Madam Speaker. Madam Speaker, on behalf of the Opposition, I wish to associate myself to the tribute paid by the Honourable Prime Minister to late Mr. Ismail Hassan Jinawu. And Madam Speaker, may I request you to direct the Clerk of the National Assembly to convey our deep condolences to the bereaved family. Thank you.
Yes. Honourable Members, I associate myself with the tribute paid to the memory of late Ismail Hassan Jinawu, former Member of Parliament, by the Honourable Prime Minister and the Honourable Leader of the Opposition, and I direct the Clerk to convey the deep condolences of the Assembly to the bereaved family. Yes, Honourable Members, I have an announcement. Honourable Members, on the 29th of November 2024, you elected me unanimously as Speaker of the National Assembly. And last Saturday, therefore, I could mark my 1 full year in this position. Last Tuesday, I had to suspend the sitting as the aggressive behaviour of some members had reached its peak after I had already given 2 warnings that I would do so if there was no order in the chamber. I learned in the meantime that Honourable Adrien Duval accused me of being partial. He did this on Top FM radio. On his Facebook page, which I read, he said that I was trop souvent dépassé par les événements. Indeed, a journalist of Top FM asked me for declaration, which I gave him very briefly, but I invited him to listen to my announcement, which I'm giving now. I accepted this post, Honourable Members, on the clear understanding that I would be totally independent. And I invite Honourable Duval to raise his objections here about my partiality by way of a substantive motion and not just lightly. You can see Standing Order 45. 40(5). He may not like the way that I have adopted for the past year. He's free to hold his opinions. But concerning the conduct of a speaker, there are rules. Now, Honourable Member, I want to refer to the incident which made me suspend the sitting. Everything is in a Hansard. By the way, now that we have direct broadcast, a very wide audience was also witness to the situation to see how it deteriorated. Any honourable member will by now have had the same amount of time as me to read the Hansard and to understand how things happened. The decision to suspend the sitting, rather than order members out, was mine. I fully stand by that decision, which is based on Standing Order 77, which gives me a wide power to regulate the conduct of business in the Assembly. I am not going to repeat negative decisions of the past by ordering members out or naming anyone, because the place of honourable members is in the House and not anywhere else. This applies to members on both sides of the House, and I count on all of you to help me to maintain the decorum of the House. Anyone who does not agree with what is going on is free to raise a point of order and ask for my ruling. But points of orders must respect the standing orders and rules of the National Assembly. May I refer honourable members to Standing Order 41. Further, may I also remind you, once more, that sometimes I need to take time to give a ruling precisely, as I must read the Hansard to understand clearly what happened. They say fools rush in where angels fear to tread. It is better to take time in order to be fair and make a proper decision, but my decision cannot be questioned. I also want to remind members that at question time, we need questions and not statements from honourable members. All the preliminaries are not permitted. In fact, it is easy with the English language to ask a question by incorporating the fact on which the question is based, rather than make a long-winded introduction which will clearly call for unpleasant remarks. This applies again to both sides of the House. I will not allow long introductory remarks anymore. And if there's no need, and there is no need for members to give rulings as if everyone is a speaker in this House. Please let me do what I am here for. Now, for ministers who are replying to a question, it is not acceptable to use 20 minutes out of 30 to answer a private notice question. We will have to find a good solution on such issues. Even for PQs, ministers are invited to be precise in their answers. If not, an answer which requires a long explanation may be tabled. Then members will have to put supplementary questions, if need be, or take notice of the reply, and in due course come back with a new question, unless there is an urgency, of course. As for the private notice question, it is a time for the leader of the opposition, who exercises this right according to our standing orders, and it is a long tradition in our democracy based on the Westminster system. Any other member who wishes to put a supplementary question must wait for the leader of the opposition to finish with his supplementary questions before putting a question. Once a member catches my eye, he or she must wait. Last and not least, I will not tolerate any member who addresses me in a sitting position. Thank you.
Questions?
Yes, Honourable Leader of the Opposition.
Thank you, Madam Speaker, I was waiting for your go-ahead. Madam Speaker, I've given notice of the following private notice question addressed to the Honourable Prime Minister, Minister of Defence, Home Affairs and External Communications, Minister of Finance, Minister for Rodrigues and Outer Islands, whether in regard to the forthcoming Pay Research Bureau report, he will A, for the benefit of the House, obtain information as to where matters stand regarding the preparation thereof, indicating the expected date of publication, and B, state whether funds have been earmarked for the payment of the recommended salary increases, indicating 1, whether government will bear the costs at one go, 2, whether it will be implemented with retroactive effect, and 3, as from when payments will be effected, including arrears, if any. Thank you, Madam Speaker.
Yes, Honourable
Madam Speaker,
Prime
with your
Minister.
permission, I shall reply to this question. Madam Speaker, as stated in the House before, that is, since 1982, the Pay Research Bureau has conducted the general review exercise on pay and grading structures every 5 years, except for the 2016 report. The 2016 report was published after a period of 3 years only. The 2016 PRB report, however, re-established the periodicity of the general review exercise for 5 years, and consequently the last one was in 2021. I'm informed that preparation for the next report started in March 2023, according to a preset work plan. Madam Speaker, it is worth to note that apart from ministries and departments, local authorities and the Rodrigues Regional Assembly, there are some 125 parastatal bodies that fall under the purview of the Pay Research Bureau. The Bureau has to gather maximum information to facilitate interaction and exchange of views with all stakeholders. So far, the Bureau has had more than 675 meetings with staff associations and management of both parastatal bodies and the civil service. 1,710 interviews have been conducted in relation to job description questionnaires, and 17 site visits have been effected to examine alleged problem areas highlighted by stakeholders. Madam Speaker, as the House is aware, the report on the state of the economy, which was published in December 2024, clearly demonstrated the precariousness of the economic situation. The previous government left a much larger deficit that had been announced. Public sector debt had reached an unsustainable level, and all the macroeconomic fundamentals were in the red. It is in this particularly difficult context that we are presented a budget which obviously required drastic measures to redress public finances. It is against this background that the PRB report is being prepared. As regards to Part A of the question, the preparation is at an advanced stage. As regards Part B1, 2, and 3 of the question, it is difficult for me at this stage to give an indication of the implementation of the PRB report, as the cost implications of the report are still unknown.
Thank you. Yes. First supplementary.
Yes, Madam Speaker. Again, I see that government is not keeping another electoral promise. That is, to publish, which was to publish, because they said that before the elections, to publish the report in December and payment to be effected by January next year. Madam Speaker, there has been an erosion in the purchasing power of employees in general and in all sectors since the last budget. Will the Honourable Prime Minister reassure the House that the PRB report will redress this situation, at least in the public sector, Madam Speaker?
Madam Speaker, I'm not sure what the leader of the opposition means when he says address the situation. The situation of the economic catastrophe that you've left and how we will address the issue. Yes,
No,
purchasing power.
not in a sitting position. Yeah, please sit down. Please sit down, Prime Minister. You, let him sit down, now you answer. Yeah, don't speak to me. Don't speak,
My
yes.
question is clear. It is with regard to the loss of purchasing power, and I referred to the civil servants of this country.
Okay, Prime Minister.
Will that be addressed?
As I said, Mr. Speaker, so we're working on it, but we have an unprecedented situation where the deficit, he knows, the debt is much, much higher than anyone expected. We knew they were cooking the books and the figures, but we did not expect to see that kind of disaster that we have nurtured. It is in that context that it is being prepared.
Second question.
The Honourable Prime Minister is making reference to the state of the economy. His Minister
Ma-
for Civil Service is not
Leader
even
of
in
the
the country,
opposition.
is travelling.
We
Madam
just
Speaker.
said that you will come with questions, not statements.
Now, if this is the case, Madam Speaker, may I ask the Honourable Prime Minister to inform the House whether the Pay Research Bureau has the capacity to carry out such an exercise with regard, I'm referring to the alignment of the salary structures, okay, and whether you will ensure that there is a continual review of the pay grading structures, Madam Speaker.
Yes, we have the capacity and this is being done.
Third question, Leader of the Opposition.
Madam Speaker, the government recently modified...
No, question.
Yeah, I'm putting, let me explain why I'm putting
Put your
that
question. And
The government recently modified the criteria for promotion from O-level to A-level, that is from 5 to 3 credits. Can the Honourable Prime Minister inform the House whether this measure has already been included in the recruitment exercise in the public sector?
this is
And
PRB.
may I remind the House, I put the question to the Minister for Labour and he was agreeable to what I said at that time.
But we're talking of the PRB now.
Got the question again?
Prime Minister.
It's not directly related to PRB, but yes, we are proud, in fact, that we are not leaving students who have had only 3 credits on the side of the road. We are taking them in. They are part of Mauritius and they have to be catered for.
Madam Speaker, as a gesture of solidarity towards those who are today facing difficulties in the country, can the Honourable Prime Minister confirm whether the salaries of elected members of this House will not be increased in the forthcoming PRB report?
I said, it hasn't been increased apparently since 2016. Nothing has been done for salaries. But as I said, we look at the context and this is what we're working on.
Madam Speaker, government has recently introduced measures to reduce the number of vehicles on our roads by the introduction of taxes on certain vehicles. Will government consider reviewing the facilities provided to elected members and their respective political nominees on duty-free cars and other accessories in order to reduce expenses in the
You
country?
mean new ones, of course. I'm in very old one.
Nothing to do with the PRB, but he might remind him that this in fact is the case. When, except when it is essential, otherwise no.
Madam Speaker, can the Honourable Prime Minister confirm to this House whether the salary gap between the lowest earner, that is, for example, a general worker, and a permanent secretary will be reduced in the forthcoming PRB report?
I'll just explain, Madam Speaker.
Can you answer this, Prime Minister?
Yes.
Of course not, yes. But he heard.
He heard.
Yes, everybody heard.
Yeah. And I saw the reactions also, Madam Speaker. Can the Honourable Prime Minister inform the House whether the PRB report will address certain working conditions, especially for posts which do not require constant on-site presence with a view to reducing road traffic? And can he confirm whether a study has been carried out?
I'm not quite sure what he's referring to. You want people not to go on site at all.
Work from home, I'm saying.
So
Don't
they
speak.
haven't got to go and check things. They'll do it from home.
Do I understand, Prime Minister, that if work from home is possible, you have no objection?
Yeah, of course not, but there are certain things that you have to go on site to see what is happening.
Yes.
Yeah, but that's what I'm saying, whether a study...
Don't speak.
For this reason, I'm asking whether a study has been carried out, Madam Speaker.
Has there been a study, Prime Minister? Has there been a
We
study?
don't need a study. This is being done worldwide, in all democracies. I hope the Honourable Leader of the Opposition, I'm not saying we can do National Assembly from home. We have to be here.
We did it during COVID.
We have, yeah, COVID was an exception.
Honourable Leader of the Opposition, today you're speaking from a sitting position. You don't normally do that.
This is an important issue, Madam Speaker.
Normally you
Now-
respect me.
Can the Honourable Prime Minister inform the House whether the forthcoming PRB report will address the lack of interest of our youth for jobs in the public sector?
This has nothing to do with the PRB report, Madam Speaker. The PRB report is, as I said, from 1982 is going on, and even when you were in government.
Honourable Prime Minister, since you've been in power, there has been a trend of retired rank civil servants who made a comeback and are now heading certain departments. Will the Honourable Prime Minister reassure the House that the forthcoming PRB report will give clear guidelines to ensure that the exercise of promotion and ranks in the public service are respected?
They're always respected, except we do take people on contract where we feel we need very able people because of from the last 10 years. Go and see how promotions were made in the civil service.
Next question. You still have a few questions?
Yeah, I've got two questions
Okay.
more, Madam Speaker. In the same vein, will the Honourable Prime Minister see to it that in the forthcoming PRB report, provision is made, Madam Speaker, to make it compulsory that promotion exercises are conducted at specific intervals in the public sector?
Specific intervals for promotion.
Normally, I don't interfere in this. This is what happens when it has to happen.
Yes.
Yes, one last question. Public servants, Madam Speaker, will get their salary compensation and a review of their salaries and working conditions with the PRB. And this will not be the case for their counterparts in the private sector. Will the Honourable Prime Minister at least consider to make it mandatory for remuneration orders to be reviewed at least once every 5 years, as is the case in the public sector, Madam Speaker?
Madam Speaker, we don't take decisions in isolation. Let me remind the Honourable Leader of the Opposition that our sovereign rating is at the lowest grade, Moody's, Baa3. Despite fiscal consolidation measures taken in the last budget, our public debt remains substantial because of the legacy of the previous government. This is what we have to deal with. Our sovereign rating is clearly at a tipping point. Moody's is still watching. We are not beyond the possibility of a downgrade. This is what we want to prevent at all costs. This is why we took difficult decisions. We had to. We must act responsibly. We will ensure that our actions reverse the situation that we have inherited and put our finances on a more resilient path in line with the commitments taken in the Public Management Debt Act.
It's just a question, Prime Minister, was about the private sector and remuneration orders being reviewed every 5 years. Can you take any give us a reply on this?
We are looking into this as
Yes.
it's a global picture that we
I'm
have
sure.
to look at.
Yes. Mr. Duval.
Yes, thank you, Madam Speaker.
Honourable.
Yes, may I ask the Honourable Prime Minister how does he intend to boost up morale in the civil service, especially in the police force, when he's renegated on his promise to pay back PRB, whilst he's made it a top priority to triple the salaries and benefits of advisors, senior advisors who were earning 90,000 rupees, and now the top ones, including the Ministry of Finance, are earning, including gratuity, 240,000 rupees.
That is not the case, Madam Speaker.
Okay. Okay, thank you very much, everyone. Now we go to PMQT, Prime Minister's Question Time. Honourable members, the table has been advised that PQB 1126 will be replied by Honourable Minister of Foreign Affairs. Yes? And I now therefore call on Honourable Third Member for Bobassin-Petite-Rivière, Mr. Kirin.
B1108, please.
Madam Speaker, the previous MSM government did everything, and I mean everything, to undermine the horse racing industry and to weaken the MTC. All that was done on purpose to favor private shady interests, and it was in this context that COIREC was set up to fulfill their ambitions. During the election campaign, we had vowed to restore public trust in Mauritius' historic horse racing industry, which has been part of the island's culture for the last 200 years. As initiated in our government program 2025-2029, this government has successfully restored public confidence in the horse racing industry, as witnessed from the first racing day held on the 26th of July 2025 at the Champ de Mars, and also at the recent one, the Maiden Cup. Under the previous government, the horse racing industry was being driven towards its demise. That was the purpose of what they tried to do. With regard to Part A of the question, I'm informed by COIREC that the board currently comprises the following official members. Acting Chairperson, Mr. Anne Charles, who is the Financial Secretary. Directors, Mr. Bungali, Assistant Solicitor General. Mr. Mohabir, Deputy Chief Executive of the Economic Development Board. Mr. A.K. Sitaram, Director of Tourism, Ministry of Tourism. And Ms. Sharon Yongtikau, Assistant Permanent Secretary at Prime Minister's Office. The monthly fees payable to the chairperson and directors are 42,000 rupees and 15,750 rupees, respectively. Regarding Part B of the question, I'm informed that following amendments to Section 29 of the States Land Act in the Finance Miscellaneous Provisions Act of 2022, COIREC was, as from May 2022, entrusted with the control and maintenance of the state land at Champ de Mars. Accordingly, on 1st of July 2025, a lease agreement was signed between the MTC Jockey Club and COIREC for a period of 10 years, that is up to 2034. Of course, the MTC then had to oblige because this was the plan. Under this lease agreement, the responsibility for the management, maintenance, and upgrading of racetracks falls under the responsibility of the MTC Jockey Club Limited throughout the lease period, which, as I said, I think ends in 2035. As regards Part C and D of the question, I'm informed that a rental fee of 250,000 rupees per race meeting, excluding VAT, is payable by the MTC Jockey Club to COIREC. Provisions have been made in the lease agreement for a yearly increase of 5% in the fee payable. MTC Jockey Club Limited has the right to commercially exploit the Champ de Mars, including the collection of rentals and any other income derived thereof, subject, of course, to the consent of the lessor. Madam Speaker, in July 2025, amendments were brought inter alia to Section 31 and 32 of the Gambling Regulatory Amendment Act, and provision was made for any statutory body or government-owned company to take control and maintenance of the Champ de Mars. Accordingly, COIREC is being wound up. All its activities and assets and liabilities and obligations are being transferred to a specific entity operating under land scope Mauritius with clearly defined governance structure. During this transitional period, the board is overseeing ongoing operations, ensuring compliance with all the statutory obligations, and approving all matters necessary to facilitate an orderly winding down and closure of the company.
Yes, all right. Honourable third member for Vieux-Grand-Port-Rospel.
Thank you, Madam Speaker. PQ B1109, please.
Madam Speaker, I'm informed that the old Grand Port Civil Status Office was opened in December 1984 and was operational twice weekly, on Tuesdays and Thursdays, because of the low frequency of members of the public requiring civil status services. The old Grand Port Civil Status Office was closed in July 2013. Since then, the residents of Grand Sable, Old Grand Port, Bambou-Virieux, and surrounding areas were availing of the civil status services at the Mayberg, Rosebel, Plaine-Magnan, and Bel-Air Rivière-Sèche. The Mayberg Civil Status Office is the closest alternative office, easily accessible to the inhabitants of Grand Port, and is fully operational for 5 days a week. However, Madam Speaker, I'm further informed that the renovation works for the old Grand Port Civil Status Office is being done and will be completed by next month. The recruitment exercise to fill vacancies for 13 civil status officers is ongoing. Thereafter, the old Grand Port Civil Status Office will be reopened, hopefully by March 2026.
Yes, Mr. Ramdas, you're all right? Yes, the Honourable second member for Audrey, Mr. François.
Yes, thank you. B1110.
Madam Speaker, let me first inform the House that the sub-office of the Financial Crimes Commission in Rodrigues has now moved from Camp du Roi to Rue de la Solidarité in Port-Maturin. Madam Speaker, I'm informed by the Financial Crimes Commission that the sub-office is manned by 2 investigators and 1 woman police officer. In addition, the operations of the sub-office under the supervision of 1 chief investigator from the Financial Crimes Commissions based in Mauritius. In relation to Part B of the question, I'm informed that the sub-office is equipped with all the necessary facilities for its operations, and arrangements are also made for officers of the Financial Crimes Commission based in Mauritius to proceed to Rodrigues for interrogation of suspects in high-profile cases as and when required. As regards to Part C of the question, 52 cases have been registered at the sub-office in Rodrigues during the period March 2024 to date. Out of these, 32 cases have been completed and 20 are still under investigation.
Thank you, Prime Minister. Yes, the Honourable second member for Grand Bipou-Brodon, Mr.
Thank you,
Media.
Madam Speaker. B1111.
Madam Speaker, as per the information gathered, Mr. Ravi Yerigadu, barrister at law, provided legal services for the following public institutions and has received fees as stated below. 10.9 million rupees from the SBM Group for a period 2017 to 2024. 10.7 million from the SIC Group for the period 2017 to 2024. 4 million from the GRA for the period 2019 to 2024. 2.4 million rupees from the Mobank Group for the period 2017 to 2025. 1.1 million rupees from the Bank of Mauritius in June 2022. 920,000 rupees from ICTA for the period 2022 to 2024. 637,850 rupees from Airports of Mauritius Company Limited in 2022 and 2024. 603,750 rupees from the Mauritius Police Force
Honourable Minister, please.
during the tenure of the former Commissioner of Police for the period of 2023 to 2024. 393,300 rupees from the Mauritius Duty Free Paradise Company Limited in 2023 and 2024. 320,000 rupees from the S Investment Support Program Limited. 204,960 rupees from the Mauritius Shipping Corporation Limited for the period of 2018 to 2019, and 39,200 rupees from the Mauritius Society of Authors during the period 2019 to 2020. Madam Speaker, Mr. Rigadu, another blue-eyed boy of the previous regime, who enjoyed, Honourable Juval asked me a question about advisors. Look how much money was given at the time, when he enjoyed extreme largesse, as he was providing legal services to not less than 12 government entities from 2017 to 2025. He has, during that period, received fees, Madam Speaker, totaling 32.2 million rupees from various institutions. That is the scandal. I wish you had asked the question then. In view of some disturbing facts that have emerged from the circumstances under which the services of Mr. Yerigadu has been enlisted as legal advisor and the quantum of fees paid, an inquiry will be initiated.
Yes, all right. The Honourable third member for Gobert-Petite-Rivière, Mr. Kira.
B1112.
Madam Speaker, in accordance with the Value Added Tax Act, small businesses and entrepreneurs whose turnover are between 3 million and 6 million rupees are required to file the first VAT return on or before 31st of January 2026 in respect to the period 1st of October 2025 to 31st of December 2025. A small business or entrepreneur submitting the VAT return after the 31st of January 2026 will be liable to pay penalty for non-submission of VAT return and no payment of VAT. Madam Speaker, there is no amnesty provided on tax due by taxpayers. However, small businesses and entrepreneurs will be given a 1-month extension of time, that is up to the 28th of February 2026, to submit the return and pay their VAT without being liable to penalty or fees. Following the announcement in June 2025 in the budget speech 2025-2026 to reduce the VAT registration threshold from 6 million to 3 million rupees, MRA has taken a series of measures to assist small businesses and entrepreneurs to properly prepare and file the VAT return. Namely, a communique was issued on the 12th of September 2025 requesting persons required to be registered and who need assistance to phone on the MRA hotline or to use the MRA e-appointment facility. B, dedicated customer service desks for the SMEs requiring assistance have been put in place at the MRA head office. C, simplified VAT registration system have been put in place. D, a guide on simplified VAT registration is published on the MRA website. E, a guide on simplified record keeping has also been prepared by the MRA. And F, the MRA has invited the newly VAT registered persons to attend dedicated education sessions. Madam Speaker, I'm informed by the Mauritius Revenue Authority that at 27th of November 2025, a total of 6,518 VAT registration applications have already been received by the MRA compared to the estimated number 6,900 new taxpayers for the financial year.
Thank you. Yes, Mr. Kira.
Merci, Madame la Présidente. Le Premier ministre peut-il informer la Chambre si le gouvernement pourrait envisager d'accorder une exonération ou tout le moins un moratoire de 6 mois au lieu d'1 mois comme il l'a mentionné, afin de permettre à ces entreprises de s'acquitter de leur premier versement de la TVA dans des conditions soutenables.
It's going to be very difficult to do that, Madam Speaker, for the reasons I gave early on. We have to be sure that we collect the taxes. We have given an extension. That's what we are sticking to.
Okay, Mr. Duval, you wanted?
Yes. Ask the Prime Minister whether he will consider exempting those persons who offer services in coaching, sports training, academies, etc. My understanding is that they are subject to payment of VAT whilst they are promoting a healthier living. So could he review at least that aspect to look at promoting healthier lifestyles, exempting those companies and entrepreneurs from payment of VAT?
That's what I was about to say. All services, because the minute we make exceptions, you will see other people with also exceptions. We have to ensure and act responsibly that we do not allow the public debt to increase, and we get what we are supposed to get in the finances of the coffers of the government, so that we can address the issue that Moody's is looking at very carefully.
Okay, next question. Mr. Lubin, I think.
Yes, thank you, Madam Speaker. B1113, please.
Madam Speaker, I'm informed by the Mauritius Ports Authority and the Cargo Handling Corporation Limited that representations have been made in writing on the 20th of August and 10th of September 2025, and also verbally on a few occasions by the Mauritius Export Association and the Mauritius Chamber of Commerce and Industry on behalf of the members regarding delays in the delivery of containers, thus impacting on the business community. Such delays occur mainly after adverse weather conditions, during which container handling operations are suspended for safety and security reasons. The operations of the Cargo Handling Corporation Limited are further affected through the shortage of rubber-tied gantry crane operators and insufficient ship-to-shore cranes. The corporation has presently 5 such cranes which are already operating at full capacity. I wish to inform the House that 3 out of the 8 ship-to-shore cranes, having reached the end of their economic useful lives, were removed from our operations since February 2023, and they were not replaced. These factors slow down vessel performance and affect productivity negatively. Owing to these delays, 10 container vessels carrying a total of 4,396 import containers skipped their calls at Portly Harbour for the period June to August 2025, and this has repercussions on the local market. These ships have been diverted to other regional ports, and the containers ultimately reached Port Louis with significant delays ranging from 4 to 8 weeks. To address this issue, the Mauritius Ports Authority had a meeting on the 22nd of August 2025 with the Cargo Handling Corporation Limited, the Mauritius Export Association, the Mauritius Chamber of Commerce and Industry, as well as the shipping lines, to identify and implement remedial actions. Consequently, the situation has improved, with all diverted containers reaching Port Louis, albeit with some delays, but not such long delays. Madam Speaker, to further improve its services, Cargo Handling Corporation Limited has started the training of 32 employees as rubber-tired gantry operators since last month. In addition, the Government of India is providing, free of cost, a cargo handling equipment training simulator for hands-on training. The Government of India would concurrently depute a technical expert for a period of 2 years for the training of operators. Delivery of the simulator is expected by the end of this year. Madam Speaker, in reply to Parliamentary Question B471 at our sitting of the 13th of May 2025, the House was informed that to enhance efficiency and competitiveness, the Cargo Handling Corporation was proceeding with the implementation of its business plan at the cost of 5.3 billion rupees, with acquisition of the state-of-the-art equipment, implementation of green initiatives, capacity building, and digitalization of operations. This plan is being implemented in 2 phases, and the first phase, of a period of 2 years, comprises the acquisition of the following cargo handling equipment at the cost of 2.77 billion rupees to be financed by the corporation's own funds. 1, an acquisition of 2 superposed Panamax ship-to-shore cranes. 2, acquisition of 5 hybrid rubber-type gantry cranes. And 3, procurement of 15 tractors and trailers and other associated yard equipment. Action is also being taken by the Central Procurement Board for the floating of international tenders. In regards to the second phase, I wish to inform the House that the Government of India has extended a grant for the acquisition of port equipment by the Cargo Handling Corporation to the tune of 3.3 billion rupees, which would include the procurement of 1 Superpost Panamax crane, 8 rubber-tired gantry cranes, and other associated yard equipment. In this context, the Ministry of Finance is in the process of signing a memorandum with the Government of India. As I have stated in the House, Madam Speaker, a total revamping of the port and other infrastructure to support maritime economic activities is being envisaged. In this context, following my state visit to India last September, the Indian authorities have agreed in principle on the strategic side for the redevelopment and restructuring of port in Mauritius.
Thank you. Yes. Yes, Dr. Amir?
B114, please.
Madam Speaker, with regard to Part A of the question, I am informed by the Commissioner of Police that from the 1st of January 2022 to the 28th of November 2025, 806 cases of road traffic accidents due to driving under the influence of alcohol or illegal drugs or without holding a valid driving license were reported to the police. Out of those 806 cases, 287 were fatal road accidents, out of which 25 cases concerned driving under the influence of alcohol, 8 cases involved driving under the influence of drugs or intoxicating substances, and 8 cases concerned driving without a driving license. In regards to Part B of the question, I'm informed that 110 vehicles rented as contract cars were involved in road accidents, among which 4 were illegally rented cars. Out of the 110 rented vehicles, 2 were involved in fatal road accidents while driving under the influence of alcohol, and 1 under the influence of drugs or other intoxicating substances. These figures, Madam Speaker, are a stark reminder that reckless and unlawful driving behaviors, be it under the influence of alcohol or drugs, or without a license, continue to claim lives on our roads. Government remains fully committed to reversing that trend through stronger enforcement, enhanced legislation, and smarter technology. In this regard, amendments to the Road Traffic Act is being introduced, in fact, this very evening in the Assembly. The amendments will reinforce deterrence and ensure that our legal framework keeps pace with evolving road safety challenges.
Thank you. Dr. Amir?
Thank you, Honourable Prime Minister. With regard to the forthcoming legislation for what we call PME Act 1, may I ask the Honourable Minister whether consideration will be given for those that have resulted in fatalities where there has been drink driving and illegal consumption of drugs, that the very harshest penalties be considered, such as full suspension of their license for life. Thank you.
I think this is already taken care of in the road traffic.
Taken care of, okay.
One more, please.
One more, and then your next question.
Sure. Thank you, Madam Speaker. May I also ask the Honourable Prime Minister whether he will use his good office so that the court system in this country introduce a fast-track system whereby there have been fatalities secondary once again to drug driving or illegal consumption of drugs, so that the chances of being released on bail, which cause so much discomfort to bereaved families, are minimized, and these people are put behind bars at the quickest opportunity that the court can find.
But that
Thank you.
depends on the court.
Yeah, in fact, yes, but I can say that the Attorney General, in fact, is looking at all these measures. There's some opposition to it, I must say, but we are going to go ahead with that. We need to have a fast-track justice wherever there are problems like this. We can't wait for 6 months, 1 year, 2 years.
Okay, interesting. Dr. Amir, your next question.
B1115, thank you.
Madam Speaker, I'm informed by the Financial Crimes Commission that 88 suspects have been arrested under the provisional charges since November 2024 to date. In relation to the information regarding charges leveled against each suspect, The Financial Crimes Commission has advised that by virtue of Section 161 of the Financial Crimes Commission Act, no information relating to any investigation can be divulged. As regards Part B1 of the question, I'm informed by the Financial Crimes Commission that 8 such suspects needed medical attention and proceeded to private clinics or to public hospitals. I'm tabling the details of the 8 suspects who needed medical attention. Out of the 8 suspects, Madam Speaker, 1 obtained bail whilst under medical care. As regards Part B3 of the question, 3 suspects spent time both in police custody and in private clinics pending their release on bail.
Thank you. Yes. 2 questions.
Thank you, Madam Speaker. What I'm going to say, the whole House is aware. Keeping in mind that the Honourable Prime Minister himself, while he was under vile persecution, he did not at any time attempt to replace prison with luxury confinement, but faced the music and went to Mocha Detention Center. Can I ask the Honourable Prime Minister whether he will consider that a medical unit be made available either in Melrose Clinic or at the FCC, particularly with specialized care in cardiology, because most of them have cardiac issues, to avoid the tactical use of medical conditions to remain in such hospital institutions.
I totally agree with the Honourable Member, and I can tell him, and I can tell the House that this in fact is being considered by the Attorney General, and we're going to come with legislation addressing this issue.
Yes.
Thank you, Madam Speaker. I know I'm taking a lot of time today, but it is my specialty, my expertise.
Don't waste time then.
Will the Honourable Prime Minister use his good office to advise the Ministry of Health to allow specialists or senior specialists in subspecialty care to visit suspected people who have been suspected that have been conveyed by the FCC or Central CID at public hospital and liaise with them and give them the authority to liaise to provide the best medical attention so that once again, the use of private institutions cannot be used as an attempt to show justice à deux vitesses. Thank you.
Yes, again, I totally agree with the Honourable Member, and we are addressing this issue. We have public hospitals. Why the hell do they have to go to private clinics and stay in comfort? No, this is going to be addressed.
Thank you. I will allow Mr. Jaman last question, and I will give you your supplementary as well.
Thank you, Madam. Question B1116, please.
Madam Speaker, in my reply to B405 on the 6th of May 2025, I informed the House that an amount of 3.55 billion rupees was deposited by government-related entities in Silverbank Limited. This was purposely done to create a misleading enhancement of the bank's balance sheet. The decision to invest so much money in such a dubious bank with no track record was outright incompetence, bordering, I should say, on criminal offense in the exercise of the previous administration duty in safeguarding public funds. So much was invested in Silverbank Limited, despite the then government themselves issuing a circular requesting government-related entities to invest the surplus cash balances into the treasury certificates, which are much safer. They issued the circular, and yet this is what they did with Silverbank. Stealing public money, that's what they were doing. As of date, more than 900 million rupees are still due to these government-related entities. I'm informed that the Bank of Mauritius, by virtue of Section 65 of the Banking Act of 2004, appointed Mr. Arvind Singh Gokul as conservator of Silverbank Limited on the 13th of February 2024. And believe it or not, a monthly fee of 3.5 million rupees was payable as conservation fee. Since Mr. Gokul was Director of Advisory Services at Grant Thornton, Advisory Services Limited, the monthly fee was payable to the company. As from the 16th of November 2024, the Bank of Mauritius negotiated the fee and it was revised downward to 2.5 million rupees per month. I'm informed by the Bank of Mauritius that the current management retained the services of Mr. Gokul as it would have been costly to replace him. However, the new management decided that even 2.5 million rupees was too high and reduced it to 1.5 million rupees as from the 18th of December 2024. Due to the substantial delay in finalizing the proposed sale of the Silver Bank Limited, the new management of the Bank of Mauritius further reduced the fee to 300,000 rupees per month with effect as from the 1st of February 2025. With regard to Part A1 of the question, I'm informed that the Bank of Mauritius has, for the period from 13th of February 2024 to March 2025, has paid a sum of 39.7 million rupees to Grant Thornton Advisory Services, with the employer on Mr. Arvind Singh Gokul. As regards to Part A2 of the question, I'm informed that the Bank of Mauritius on the 31st of March of this year, Mr. Gokul resigned from Grant Thornton Limited, but the conservation fee of 300,000 rupees per month is now being paid to Vedanta and AA Services, of which the same Mr. Gokul is the sole shareholder and director. An amount of 2.3 million rupees have been paid to Vedanta AA Services from April 2025 to date. With regard to Part A3 of the question, I'm informed that the Bank of Mauritius that no other firm or individual except Mr. Gokul has served as conservator of Silver Bank since the 13th of February 2024. As regards to Part B of the question, I'm informed by the Bank of Mauritius that for the period of February 2024 to 27th of November 2025, only 206.3 million rupees have been recovered out of the total loan portfolio of 8.2 billion rupees of Silver Bank Limited. This, Madam Speaker, represents only 2.5% of the total portfolio. This gives us a stark indication as just how toxic the Silver Bank loan portfolio is. The toxicity of the loan portfolio was directly exacerbated by the influence of the previous government. I must say to the House that it is a shame that he is still there. But there are reasons that they've given me because of the cost of paying compensation and all those things. But all this will be subject to an inquiry.
Yes, Mr. Jamal? Yes? Time is up. I said I would give him one, but time is already up. Now, the table has been advised that the following PQs have been withdrawn: B1119, B1120, B1121, B1122, B1123, B1125. Thank you. Now we go to questions to ministers. Mr. Kazer?
Yes.
Yes.
Thank you, Madam Speaker. PQB 1128, please.
Madam Speaker, I would like to thank the Honourable Member for this question. The MOPAS application is a single sign-on platform which creates the bridge between the physical world and the virtual world. So it helps the government identify citizens using services which are deployed on the internet, deployed by the government. It's a very critical application, and hence I understand the question. So services that are available today for which we have to authenticate through MOPAS include application for jobs with the Public Service Commission, downloading birth certificates, marriage certificates, renewal of motor vehicle licenses, application for certificate of character. So we can count more than 100, Madam Speaker. As regards to part one of the question, the MOPAS application has, as at 1st December 2025, 427,467 users or Mauritians registered on that system. As the House is aware, on 26th of 2025, we actually published the blueprint, and the blueprint takes into consideration the usage of MOPAS and the promotion of that usage. My ministry has therefore embarked on a massive onboarding process to increase the number of MOPAS users. During the period of July to August 2025, 8 awareness sessions were conducted at different malls across the island, mainly during weekends, to educate citizens on MOPAS platform and to help them create their MOPAS accounts. The post office as well is also engaged in that activity. So we are also using the social welfare centers, and we touched around 1,866 citizens with that. And these efforts yielded 12,934 new registrations of citizens on MOPAS platform. So, Madam Speaker, the initiative that have been undertaken by my ministry to reach maximum number of users has been ongoing. And to reach further citizens, a team from my ministry trained around 209 officers at 8 community centers and 25 officers working in the social welfare centers on the creation of MOPAS accounts. Similar activities will now be undertaken with the Citizens Advice Bureaus. And with respect to part B, of the question, Madam Speaker, I wish to inform the House that as per paragraph 6 of the National Identity Card Regulations 2024, an applicant for a new identity card may opt for the creation of a MOPAS account and the installation of digital certificates on his or her identity card. Since the implementation of the new identity card in February 2024, 146,771 citizens have opted for a MOPAS account while applying for a new identity card. Thank you, Madam Speaker.
Thank you. Yes. All right. Honourable members, the table has been advised that PQB 1133 will be replied by the Honourable Minister of Social Integration, Social Security and National Solidarity. PQB 1150 will be replied by the Honourable Minister of National Infrastructure. Yeah. Now we proceed with Honourable Third Member for Vieux-Grand-Port, Rosebel.
Thank you, Madam Speaker. PQB 1129, please.
Madam Speaker, I'm informed that the drain works in the southeast region concern 6 villages, namely Rivière-des-Créoles, Vieux-Grand-Port, Bois-des-Amourettes, Ange-Doncé-Providence, Petit-Sable, Grand-Sable, and Bambou-Verrieux. With a view to mitigating flooding in the region, the NDU has appointed consultant Servan Singh Jadhav and partners, Consulting Engineers Limited, for a thorough study of the whole region. Geotechnical investigations have also been carried out to assess soil stabilization measures along track roads and mountain slopes before proceeding with the construction of major cut-off drains in all the 6 villages. The detailed design report has already been finalized, and the whole project is estimated to cost some 576.15 million rupees, including VAT and contingencies. The consultant has been requested to advise on immediate short-term measures which may be implemented to bring relief to the inhabitants pending implementation of the drain project holistically. Madam Speaker, the Road Development Authority has also implemented 2 projects at Rivière-des-Créoles as follows. First, construction of a reinforced concrete parapet wall along diverted drainage path at Rivière-des-Créoles near underpath at Rivière-des-Créoles. And second, stabilization works designed and built on turnkey basis at Rivière-des-Créoles along South-Eastern Highway A15. Madam Speaker, with regards to the region of Nouvelle-France, I have to inform the House that the NDU has already implemented drain projects in different alignments as follows. Alignment 3, drain works along A9 Road, Second, alignments 3.1 to 3.3 upstream of A9, and alignment 6 from Coville to near community center. Third, construction of retention basin Poncy in the region of Kanpur, Nouvelle-France, and D, desilting of river Lachaux, 1 kilometer stretch, and other flood mitigating projects undertaken by the RDA include redesign of Nouvelle-France roundabout on motorway M1, drain works along A10 road at Nouvelle-France at the level of Nouvelle-France police station to roundabout on motorway M1, and alignment 6.1, drain works along A10. Madam Speaker, as advised by the LDA, the NDU has also embarked on the construction of retention basins and drainage alignment along the upstream of Sèvres-Mart, Comlon region, and Savant-Lake Road. The design was approved by the LDA on 30 September 2025, and action is being initiated for land acquisition and way leaves. Madam Speaker, as immediate measures, both the Road Development Authority and the District Council of Grand Port have been requested to proceed with the cleaning of drains and culverts within their jurisdiction in the villages of Rivière-des-Créoles and Nouvelle-France, as per the maintenance plan approved by the LDA.
Thank you. Yes, Mr. Anders.
Is the Honourable Minister aware of the number of inhabitants in respect of the Rivière-des-Créoles area, of the number of inhabitants affected by the floods? And is he also aware that certain families have had to leave their houses to seek refuge elsewhere in times of flooding?
Madam Speaker, I'm aware, and that's why we say we are working on short-term, immediate measures and long-term as a holistic measures, and the consultants are working, and I've even given the cost of the holistic project will be 576 million rupees. We know in which financial situation we are. We are trying to get financial clearance so as to do the project holistically.
Yes.
You see, I take note of the cost to the tune of 576 million. May we have an indication from the Honourable Minister as to when the works may be expected to start, and if at all they can be considered in stages, at least to alleviate the sufferings of these people in these areas?
Yes, Minister. Can you give that undertaking?
I think I've said in my answer that the consultant has been requested to advise on immediate short-term measures which may be implemented to bring relief to the inhabitants pending implementation of the drain project holistically. So we wait for the consultant to give us the short-term measures that have to be done.
I think that should be all right. You still want to? No. Ms. Tanu, please.
Thank you, Madam
Second
Speaker.
member for Quartier Militaire. Yes.
Thank you, Madam Speaker. PQB 1130, please.
Madam Speaker, I thank the Honourable Member for this question. At the outset, however, I wish to clarify that my ministry is not responsible for issuing of evacuation orders for dwellings exposed to landslides, erosion or flooding. Evacuation orders are issued by the National Crisis Committee in accordance with Section 16.2 of the National Disaster Risk Reduction Management Act of 2016, directing any person to evacuate their premises or any public place, or directing any person in a particular area to be evacuated within a certain specific time. I am informed that so far one evacuation order was issued at Rivière-des-Créoles, 5 evacuation orders were issued in the regions of Saint-Pierre and Verdun, and 6 evacuation orders were issued in Souillac during the period 2019 to 2024. Furthermore, the National Disaster Risk Reduction Management Center has informed that some 86 families are still residing in their dwellings located at areas classified as being at risk of landslides and erosion. Surveys are also ongoing in other areas, such as Crèvecoeur and Saint-Pierre, particularly along the Rivière Profonde stretch. As regards the measures, Madam Speaker, already in place and those planned to safeguard residents living in high-risk zones ahead of 2025-2026 flood season, I'm informed that regular simulation exercises, sensitization campaigns, and awareness initiatives are being carried out jointly with the local authorities. In addition, during the rainy and cyclonic periods, the following actions are inter alia undertaken. 1. Continuous monitoring of vulnerable sites. 2. Regular police patrols. 3. Issuance of alerts to expose families through the National Multi-Hazards Early Alert System. And 4. Pre-positioning and deployment of first responders, including the SMF, the Mauritius Fire and Rescue Services, and the Special Support Unit, and the regular police.
Thank you, Minister. Yes, Ms. Danu?
Thank you, Minister. Are Japanese experts currently involved in the geotechnical approach to the surveys, please? I know the experts are currently employed at the Ministry of Infrastructure. Thank you.
As I have said at the very outset of my answer, my ministry is not responsible for evacuation orders. I gave the information that I obtained from all other ministries as to what work is being done. Now, as far as specifics are concerned, I would invite the Honourable Member, Madam Speaker, to put a question to the substantive minister responsible for such geotechnical investigations. It would not be within the ambit of my portfolio, and therefore I would not be able to give the answer to the Honourable Member.
Yes, Honourable Member, you will do that, I'm sure. Now I have the Honourable Fourth Member for Port North. Yes, Mr. Duval.
B 1131.
Madam Speaker, with due respect, before addressing the question on funding, it is important to this House to recall the circumstances surrounding the land allocated to the Mauritius Tamil Cultural Centre Trust. The land at Reggie Triangle, Mocha, was originally leased to the Mauritius Tamil Cultural Centre Trust in August 2010, together with the Hindi-speaking union and the Urdu-speaking union, under the Prime Ministership of the Honourable Naveen Chandra Ramgulam. This was done in recognition of the long-standing cultural contribution of these communities and as part of a coherent national vision to support and strengthen our multicultural identity. However, in April 2023, the previous government cancelled that lease. Madam Speaker, it is publicly known that this decision was taken at a time when attempts were being made to divert the land to individuals closely connected to those in power. Such actions, understandably, generated deep resentment within the Tamil community and raised legitimate concerns about fairness and preferential treatment. Madam Speaker, the retrieval of the land was regarded by the Tamil community as a profound injustice. In August 2024, members of the community, together with the Rannulater movement, organized a peaceful march to defend their legitimate rights. Unfortunately, this peaceful mobilization was met with arbitrary arrest. This caused further distress and raised serious concerns among Mauritians regarding dignity, justice, and the protection of fundamental freedoms. What was equally troubling, Madam Speaker, is that after nearly 10 years of inaction, the previous government suddenly announced, almost on the eve of the 2024 general election, that it would construct buildings for the free organizations whose leases had cancelled. These organizations had been shifted to Kodo. The timing and manner of this announcement strongly suggests that it was motivated more political mileage than by any genuine project supported by planning, funding, or long-term commitment. Madam Speaker, upon returning to office in November 2024, this government moved swiftly and responsibly to correct the injustice created. We honored our commitment to the Tamil community by restoring the land at Reggie Triangle. A new lease agreement was signed on 20th May 2025, restating the Mauritius Tamil Cultural Centre Trust legitimate rights and rectifying the unfairness that had been inflicted. Turning now to the specific question of funding raised by the Honourable Member, I wish to state clearly that l'Alliance du Changement never pledged to provide financial support for the construction of a cultural centre building for the Mauritius Tamil Cultural Centre Trust. Furthermore, this government is not constructing any cultural centre building for any community at this stage. The economic situation inherited by this government has been nothing short of catastrophic. We are therefore required to prioritize essential national obligations such as stabilizing public finances, reinforcing social protection systems, and meeting urgent service delivery needs. In this context, embarking on new capital incentive cultural infrastructure projects would not be responsible or sustainable at the moment. This is no way diminishes our unwavering commitment to promote and safeguard the culture and heritage of all communities, including the Tamil community. It simply reflects the fiscal reality that this government must manage responsibly. Madam Speaker, this government remains firmly committed to fairness, transparency, and respect for all communities. We will continue to act responsibly and with full regard to fiscal discipline, transparency, and long-term sustainability in the cultural sector, and like our predecessor. Thank you.
Thank you. Yes?
There has been, in fact, promises made during the campaign. Maybe the Minister will not recall. I can tell you the name of members who have gone as far as the radio to say so. Well, I will ask the Minister, the Honourable Minister, whether there has been any representations with his ministry with regards to financial support for the construction which is pending since more than 20 years now there.
I think I have already replied the question. We have not committed ourselves.
No, whether
Nothing.
there were representations?
No, not at all.
Right.
Okay.
May I have a second question?
Yes?
Then may I ask whether he is prepared to receive representations from the MTCC with regards to construction, given that the promise has been made and
Honourable
I
member.
maintain,
Honourable member.
I maintain, and that therefore the subject matter ought to be discussed with them.
Minister said that there was no promise. You are asking him if he will meet representatives. Maybe you can meet representatives, Minister. Yes?
You must give evidence.
But maybe the Minister can meet representatives. Not necessarily for what he says.
Why should we meet if we are not going?
If nobody asked.
Yeah.
But if somebody asked.
If they ask, yes, of course we'll meet them.
On est à
With
Maurice.
pleasure we'll meet them, Madam Speaker.
On est à Maurice, on est bien élevé. Allez. Now I have a few minutes. Second member for my group, Pleine Manière, Mr. Apollon. Celui-là a été. Okay. This question has been withdrawn. J'ai beaucoup de mal à suivre. Hein. This question has been withdrawn. On m'envoie des tas de petits papiers. Il va falloir trouver un meilleur système. Hein. Okay. So if the question has been withdrawn, I propose that we break for lunch. Il reste 4 minutes. Now you can come. Maintenant. J'ai bu que de l'eau. Voilà. OK. Now let me see. Mr. Rukni? Yes.
Madam Speaker, B1133.
Madam Speaker, please allow me to provide the reply to this question as the budget measure 295 concerns my ministry. From the outset, let me convey to my colleague, Honourable Member, and the House the following. 1. With regards to Part A and C of the question, the scheme is expected to be implemented as from the end of this year and fully rolled out by the first quarter of 2026. In this context, provision is being made to fully cover 7,468 households and families on the SRM in both Mauritius and Rodrigues to benefit from this budget measure. 2. With regard to Part B of the question, payment will be made to Internet service providers upon provision of the Internet to SRM households who applied and are provided with same. Madam Speaker, following the announcement of this budgetary measure, the NEF, the National Empowerment Foundation, carried out survey amongst its beneficiaries, who consist of persons of the Social Register of Mauritius, SRM, and have signed a social contract to benefit from its services. The surveys pointed out that only around an estimated 10% of the families of the Social Register of Mauritius presently have a home-based internet connection. Around 90% have expressed interest to avail of the free internet connection. My ministry then engaged in consultations with relevant stakeholders, namely the Ministry of Finance, the Information and Communication Technology, ICTA, and the National Empowerment Foundation to work out modalities for the implementation of this budgetary measure. Consultations were also held with the Mauritius Revenue Authority, MRA, to understand the mechanism in place for persons to benefit from the 1825 free mobile phone scheme. After thorough reflections emanating from these consultations, my ministry has decided that eligible SRM beneficiaries will have the choice to select from the free available commercial packages, as per the recommendation of the ICTA, offered by the free internet service providers, that is Mauritius Telecom, MTEL Limited, and Mahanagar Telephone Mauritius Limited, MTML. Thus, these 7,468 households will have the possibility of making their own choices and no specific ISP will be designated. So the new provision will be a people's choice-based system. In this context, the State Informatics Limited is working on an online platform with the with the assistance of the Mauritius Revenue Authority to translate this people's choice-based system to ensure efficient implementation and monitoring of the scheme and ensure effective communication between the ministry and the internet service providers. Once the SIL online platform finalized, NEF will issue notices to all SRM eligible households to inform of the packages available and of the modalities to avail of same. The head of the household will have to apply for his or her chosen package directly from the selected ISP and its respective outlets, similar to any citizen applying to benefit from any given internet package. Madam Speaker, I wish to inform that the government has provided for, in fact, 85 million rupees yearly over a period of 3 years each for this particular scheme under the National Resilience Fund. Let me reassure the Honourable Member and the House that the 3 years period will start as from the date on which the measures become effective, so that no prejudice is caused to any of the registered poor family of the country. My ministry is committed, as is this caring government, to ensure the implementation of this measure to provide some 7,500 families and 27,000 people with internet connection so as to be digitally connected and avail of the facilities linked thereto, particularly for educational purposes. Thank you, Madam Speaker.
Minister. Yes, Mr. Oakley.
Madam Speaker, I would like to ask the Minister, Honourable Minister, if he could advise of the 85 million rupees earmarked per financial year, and given that the project will be fully rolled out at the end of first quarter of 2026, how much of the said sum will be spent in the first financial year?
As I've just stated, the project, as from the date of implementation of the project, the 3 years budget will be applied. That is, the 3 years that has been earmarked, irrespective of the start date of the implementation. So up to now, no money has been spent. So it will be spent either in December or the first 3 years of next year, and then the 3 years will apply for all those eligible to the package.
Yes. The second member for Quartier Militaire.
My apologies. I believe that the question has been
Withdrawn?
Yes.
Yes.
has been-
All right. It's quite possible, but I believe you. Okay. So now, then, I will go to first member for Savannah and Blackburn.
B1135. Thank you.
1135, Minister of Information Technology.
Yes, Madam Speaker, I would like to thank the Honourable Member for this question. This government recognises that online harms, particularly those affecting children and vulnerable persons, demand a structured and specialised institutional response. This because of also the incidents that took place lately, including attempts to and cases of suicide. I am tabling
Sorry, including one today, I understand.
Sorry?
This is, apparently there has been one today as well.
Yesterday.
Yesterday, yes.
And it was, yeah, very,
I'm
very
sorry.
sad. Yeah. Over the last 3 years, Madam Speaker, there has been an increasing number of cases of cyberbullying, online harassment, and other forms of digital violence, especially against women. When we look at the statistics which I will be tabling, those statistics reveal numbers that speak loudly about the fact that women are more exposed to digital violence. Even though the Cyber Security and Cybercrime Act 2021 already provides deterrent legal provisions, my ministry is actively working on amendments to the legislation to further strengthen the protections, given the fast evolving nature of online harms. Again, for 3 consecutive years, Madam Speaker, cybercrime has been on the rise. The data was there. Parents were reporting cases, but the former government took no action. No proposed amendments to the legislations. Regarding Part A of the question, Madam Speaker, I am informed by the Attorney General's office that the establishment of an independent online safety regulator in line with international best practices, such as the E-Safety Commissioner of Australia, the Online Safety Commissioner in Ireland, and the UK's Online Safety Act under Ofcom, is under examination. It is important to highlight that our current online safety ecosystem already includes several institutions, namely the ICTA, the Data Protection Commissioner's Office, the Police Cybercrime Unit and the Child Development Unit, along with the Computer Emergency Response Team. Together, these institutions play a critical role in protecting our children and all the users online. Nevertheless, preliminary consultations with stakeholders are being held to determine the most appropriate mechanism and options, including the creation of an independent statutory office headed by a highly qualified commissioner, or the establishment of an online safety unit within an existing regulator with guaranteed independence. As regards Part B of the question concerning the proposed ban on social media access for persons under 16 years old, Government is monitoring international developments carefully, including Australia's pioneering but technically challenging nationwide restriction accompanied by an age assurance technology trial. The Australian experience, Madam Speaker, reveals issues related to technical accuracy, privacy risks, implementation challenges, and enforcement complexities that question the practicality of such a ban. In line with Section 12 of our Constitution, which protects freedom of expression and considers the digital rights and inclusion of minors, a full prohibition does not seem to be the solution. Similarly, there is also concern that a ban may push minors to unregulated platforms, potentially increasing risks. The former government treated cybersecurity as a side issue. Today, we are correcting a decade of dangerous complacency, Madam Speaker. This government instead prioritizes a holistic approach that includes strengthened digital safety education and enhanced parent control mechanisms, including the imminent rollout of a child protection measures online, or a set of measures online. The House may wish to note that the ICTA is currently working on directives which are expected to be issued in a matter of days. This measure, while being optional, allows parental control through mobile devices in a first phase and control over Wi-Fi home routers in a second. The directives will mandate licensees to, inter alia, take necessary measures to curtail harmful and illegal content for protecting children online. Moreover, the government intends to actively engage with regional international bodies, namely the SADC, the COMESA, and the African Union, in order to establish structured channels of cooperation with major online platforms, most of which do not have a physical presence in Mauritius. This approach aims at improving platform accountability for the contents that are being hosted by those companies. I also wish to inform the House that amendments to the Cybersecurity and Cybercrime Act 2021 are being prepared to, inter alia, establish a national cyber resilience and cyber security agency, which will have as one of its key functions online safety. Whether the independent online safety regulators' functions will be incorporated into this framework or not will depend on the outcomes of the ongoing assessments. Madam Speaker, it's known to one and all that our economic stability now depends upon our social as well as digital stability. It is therefore imperative that we ensure that electronic platforms are safe and secure enough to protect our people. The past regime politicized people's safety. We are taking responsibilities. They stood by as family, women, and young people suffered digital violence. We, on the other hand, are coming with bold measures: legislative, institutional, operational, and educational. And on a conclusive note, Madam Speaker, this government is fully conscious of the increase in online risks and the corresponding rise in the number of victims. This is why it is resolutely committed to protecting our population, especially children and vulnerable persons, from online harms through legislation, institutional reform, education, technology, and international cooperation, while at the same time upholding the constitutional rights. Thank you, Madam Speaker.
Thank you, Minister. Mr. Babaji, yes?
Will the Minister consider introducing a 24/7 counseling and support services? As we saw it yesterday, someone committed suicide live, and there was a gap between that. We could have contacted that institution.
Thank you, Honourable Member. We are looking at the problem from a holistic perspective. You would recall the Prime Minister's visit to India, and as a result, we are engaging with the Maharashtra government for the establishment of certain services that will include services from Ministry of Gender for family support as well, and for support of victims who are going through digital violence.
Yes? All right. Honourable Third Member for Bobassa.
B1136.
Madam Speaker, I wish to inform the House that it is the Mauritius Football Association which is responsible for applying for homologation of a stadium in Mauritius. In order for a stadium to host international football matches, they need to get homologation by the Confédération Africaine de Football, Confédération Africaine de Football, pardon. The CAF is the governing body for football in Africa and is one of the 6 continental confederations that make up Fédération Internationale de Football, that is FIFA. The mandatory requirement to get homologation includes compliance with, inter alia, administration documentation, pitch or field of play, technical areas of equipment, dressing room, team and official facilities, match official, doping and VAR, video assistant referees, spectator areas and seating, safety, security and emergency services, media, press and broadcast, and lighting, power and communication. Madam Speaker, I wish to inform the House that my ministry is working in close collaboration with the MFA towards the homologation of 2 stadiums. It was this endeavor that inspection of both the new George V Stadium and the Anjali Kupen Stadium were carried out by Mr. Joa Nip, a CAF Stadium inspector, during his mission to Mauritius from 27 to 29 June 2025. Following the CAF inspection, the MFR was informed that both the Anjali Kupen Stadium and new George V Stadium currently do not meet the minimum CAF stadium requirement to host international matches. The CAF inspector highlighted that the Anjali Kupen Stadium requires major upgrading works in several areas to meet homologation requirement. The report also stated that the new George Stadium would require a full revamp and redesign to comply with CAF Stadium standard. Madam Speaker, I wish to highlight that the absence of an homologation does not prevent the playing of local football matches in this stadium. Nevertheless, my ministry has worked out a costing of the project, and it goes without saying that significant funds will be required for such work. The upgrading work have already started on both stadiums and will be carried out in phases. My ministry will continue to collaborate with the MFA and all relevant stakeholders to ensure that the upgrading work meet CAF standard and fully the requirement for homologation. A fresh inspection for the homologation process will be initiated once the required works have been completed.
Yes, one question.
Je vous remercie. Peut-on déduire de par la réponse de l'honorable ministre que son ministère, de même que la MFA, vont faire de l'homologation de ces 2 stades une priorité de façon à ce que les matchs de la sélection nationale ne se jouent pas uniquement au stade de Côte d'Or devant moins de 5000 spectateurs. Alors ma question, est-ce que l'honorable ministre
Il a compris.
est en train de faire une priorité, donner une priorité à ces deux stades pour être homologués dans un proche avenir?
Yes, Madam Speaker, like I said in my reply, the answer is here. We are doing our best so that the two stadiums be homologated in very near future.
And upgraded. Okay.
Madame la Présidente, rapidement,
Oui.
une dernière question. L'honorable ministre est sans doute au courant que par rapport aux deux derniers Jeux des îles qui ont été organisés ici à Maurice, l'État a dépensé plus de 230 millions de roupies pour la rénovation du stade Georges V. Donc, peut-on savoir depuis son entrée en fonction en tant que ministre des Sports?
Là, vous parlez d'un autre stade.
Non, Georges V. C'est le même.
V, d'accord.
Peut-on savoir quelles sont les mesures qu'il a prises pour rénover et s'il y a eu effectivement des rénovations qui ont été effectuées au stade Georges V?
Madam Speaker, we have waited for 10 years. I've said in my reply that we are going by phases, and the honourable member would follow what the answer, the reply was. We are doing our best.
For
so
both
we started
stadiums. For both stadiums.
for both stadiums.
Yes, all right. Next question. Honourable First Member for Portrush North and Montalon.
Merci, Madame. Question B 1137.
Madam Speaker, I wish to inform the House that the Land Drainage Master Plan, commissioned by the Land Drainage Authority, was published on 25th August 2025, following Cabinet approval. A technical committee was set up in February 2025 to review the document. Following its recommendations, the master plan, together with the associated maps and data sets, were published in its entirety. The digital elevation model was also made accessible to the public. Madam Speaker, I'm informed that since the public release of the Land Drainage Master Plan and up to 28 November 2025, a total of 358 building and land use permit applications have been referred to the Land Drainage Authority by the local authorities. Madam Speaker, I'm also informed that the time required to process building and land use permit application depends mainly on, first, the submission of a complete set of documents, including site plans, drawings of the proposed development, the computer-aided design file in required format, and stormwater drainage reports where applicable. Second, the complexity of the proposed development. And third, the examination of stormwater drainage reports where warranted. Currently, the average processing time ranges from 1 working day to approximately 2 months, depending on the complexity of the case and the completeness of the submissions. Incomplete submissions or the omission of required documents inevitably delay the processing of applications. Madam Speaker, I must admit that there has been considerable delays in the processing of building and land use permit applications, and I'm personally not satisfied with this situation. Therefore, in order to prevent undue delays in the examination of documents and the issuance of permits, a dedicated team of 4 officers has been constituted to work on backlog and expedite matters.
Yes?
Je remercie l'honorable ministre pour sa réponse. Peut-il expliquer ce qui sera fait pour ramener, j'ai bien compris la réponse, hein, le long délai avant que la LDA ne tranche sur une application? Merci.
Madam Speaker, as I just said, myself, I was not satisfied. There was only one officer working on that, on the work on all the documents and everything. Now I've set up a dedicated team of 4 officers and an engineer heading it. So I'm sure that we will be expediting matters for the permits.
Yes?
En ce qui concerne les demandes de permis pour des constructions qui se trouvent hors de la zone, de la red zone du master plan, pourquoi dans des cas également la LDA n'arrive pas à statuer et cela bloque les collectivités locales dans l'octroi du building and land permit use?
All these will be things of the past.
Yes? You're happy now, Ms. Sababati?
I'm waiting for the results.
Yes, Honourable First Member for Lacave and Felix.
Thank you, Madam Speaker. B 1138, please.
Madam Speaker, the Vakwa Popular Multipurpose Cooperative Society Limited was registered in 1977 and operates as a cooperative credit union with 4,591 active members. Its core activities include promoting savings, issuing secured loans, and undertaking property-related projects. Madam Speaker, I wish to inform the House that the affairs of the Society have been managed by a caretaker board for 10 years until 13 July 2024, when a board of directors was elected democratically. The current board was constituted on 15 July 2024. Regarding Part A of the question, I wish to inform the House that I have received two separate letters, both highlighting long-standing issues with the Vakwa Multipurpose Cooperative Society. The first, an undated letter received on 28 February 2025. The second, also an undated and received on 23rd April 2025, was addressed to the Acting Director General of the Financial Crimes Commission and copied to the Prime Minister and myself, containing serious and disturbing allegations about the Society's governance. Given the gravity of these claims, I immediately instructed my officers to initiate an inquiry, following which a comprehensive report was produced and submitted to the relevant authorities. Concerning Part B of the question, I am informed that several cases of alleged mismanagement at the Society have been referred to the police, whilst others are presently pending before courts down the years. Madam Speaker, as regard to Part C, I wish to inform the House that I have taken cognizance of the communiqué issued on the 19th November 2025 regarding the proposed Rs 560 million sale of 27 arpents 15 perches of land at Ficanflac. The communiqué was signed by the manager and the treasurer, whereas such a decision must be approved and issued by the board through duly authorized office bearers, as required under the Society's rule. The process was therefore irregular from the outset. My ministry had already issued directive before the communiqué on the 18th November and a second directive on 25th of November this year, instructing the Society to halt the process and reminding it that any disposal of immovable property requires proper board approval members' authorization at a general meeting, and more importantly, a transparent and competitive bidding exercise, which was not followed. We further reiterated the Society's AML-CFT's obligations, including full customer due diligence. As the Society initially failed to comply, all 8 of its bank accounts across 5 banks were placed under stricter transaction control as provided by the law, with any payment now subject to prior vetting to my officers, by my officers. Madam Speaker, on Saturday, 29th of November 2025, the Society formally informed my ministry that the proposed sale has been halted and it would fully adhere to my ministry's directives, including conducting an open bidding exercise and submitting the selected bidder to a special general meeting for approval. The matter is currently being followed up by my ministry.
Okay, yes, Mr. Lubin, you're all right? Okay, now we have Honourable Second Member for Vieux-Grand-Port.
Thank you, Madam Speaker. It's question B/1139, please.
Madam Speaker, all beaches along the coastal road from Bois des Amourettes to Quatre Sœurs have been proclaimed as public beaches. And on the 22nd of January 2025, the said public beaches were vested with the Beach Authority. I am informed by the Beach Authority that cleaning and maintenance of these public beaches are carried out twice weekly in collaboration with Maury Facilities Management Company Limited. This includes the collection and removal of waste from the beach and rock revêtement, as well as regular grass cutting. Embellishment works have been already undertaken at Bambou-Vieilleux, Pointe-aux-Feuilles and Anse-Jonché public beaches. Further enhancement and the planting of additional coastal vegetation will be considered subject to clearances being obtained from the Conservator of Forests. That is my answer, Madam.
Thank you. Yes? Mr. Lubin?
Madam B1140, please.
Madam Speaker, I have been apprised that the incinerator at Highlands was repaired, commissioned and handed over to the Council on 31st July 2025 by the contractor Steam House Limited. I am further informed the Council has already initiated procedures for the obtention of a fire certificate. Once a fire certificate has been issued by the Mauritius Fire and Rescue Service, the incinerator will be made operational and available to members of the public.
Yeah. Yes, Madam Speaker,
yes,
one supplementary
you see,
question.
It's all about PQs being withdrawn.
Yes.
My time is consumed
Yes.
with that. I'm so sorry.
Yes.
Go ahead.
May I ask the Honourable Minister, I know he's not the substantive minister for this question, do we have a time frame as to when this fire certificate will be issued? Because we have already visited this place on several occasions whereby we were being told that it will be operational in a few days or very soon, but it's like nearly 4 months and inhabitants over there are facing serious difficulties.
Unfortunately, the requirements of the fire services hasn't been met. For example, they have asked for the replacement of PVC tubing used to feed the water spray system with galvanized iron or steel tubing. This has not yet been done. I hope that probably in the days to come that will be accomplished.
Thank you, Minister. Yes, Dr. Prayag.
Thank you, Madam Speaker. B1141.
Madam Speaker, as I had already indicated since my taking of office, several of the sports infrastructure over the island are either out of use or in a bad state. The Rivière du Rempart swimming pool, which is managed and maintained by the Mauritius Sport Council since 1st July 2022, form part of those infrastructure which are in a bad state, although in a lower scale. I'm informed by the Mauritius Sport Council that the Rivière du Rempart swimming pool is operational and it is manned by some 15 persons. It is being used on average by some 100 users on a daily basis. A research survey and safety and health inspection have revealed that only one of the 3 water pumps is in operation. A door was damaged in the changing room, and a chemical which are currently stored in the pump room should be relocated outside. The scope of work for the repairs of the water pump is being prepared, while that of the construction of a storage facility has been finalized and tender will be launched shortly. The damaged door has already been repaired.
Yes, fine. Okay. I think I must tell you what I received from the low table. B 1126, which was to be replied, Mr. François, by the Minister of Foreign Affairs, you have withdrawn that as well. And now I have B 1142, B 1169, B 1167, and B 1153. All of these have been withdrawn. I'm going to try and follow. So now that I've finished with that, I have, Mr. Duval is not here. I will call Mr. Seaburn, Honourable Second Member. 1144? No.
1145, please.
Huh? Yes. 43, Dr. Prayag? Yes. I'm sorry. There were two questions for you.
Yes.
So I missed one.
That's okay. B 1143.
C'est un peu un
Madam
grand
Speaker,
désordre. Hein?
I wish to inform the House that in November 2021, Gift of the Givers Foundation, which is the largest disaster response non-governmental organization of African origin on the African continent, informed this ministry through Prime Minister's office that they were in the capacity to donate continuous positive airway pressure CPAP machines to Mauritius. It is good to note that an evaluation committee set up at the ministry reported that the CPAP machine, branded as CSIR LIFE, was a very basic device. It was non-invasive ventilator which was not registered by the South African Health Products Regulatory Authority. It was authorized to be used only for emergency ventilation during COVID-19 pandemic, but was not appropriate for use in COVID high dependency unit or COVID intensive care units, but could be used in COVID wards in regional hospitals. Madam Speaker, after complying with the requirements for the donation, the South African government, National Department of Health were agreeable to donate 500 CPAP machines to gift of the givers for onward donations to Mauritius. The foundation later informed that the final donation would contain 501 CPAP machines and 2,500 spare circuits packed in 167 boxes. The ministry was expected to cover the cost of the shipment from Tambo International Airport, Joburg, South Africa to SSO International Airport, arrange for custom clearance and bear the logistic cost for the storage, transportation and distribution of the machines in public hospitals in Mauritius. At the time of shipment, the agent reported that the donor informed that out of 167 boxes expected for donation, 14 boxes were damaged and a further 2 could not be sent since the serial numbers of the machines didn't match those on the packing list. Eventually, only 135 boxes were shipped to Mauritius at a total cost of 318,449 rupees and 7 cents, excluding VAT. The shipment reached Mauritius on or about 1st July 2022 and would deliver to Central Supplies Division, Castello Ministry of Health and Wellness for storage and distribution. The 139 boxes were verified by the procurement officer of the CSD and were reported to contain a total of 415 CAP machines with an expiry date of October 2022 instead of January 2023 as labeled on the boxes. Madam Speaker, 354 out of 415 CPAP machines were distributed among public health institutions. It was issued to one was issued to the High Commissioner's Office of South African High Commission, and 60 units have been expired and are still stocked at the CSD. With the permission, Madam Speaker, a detailed distribution list will be is being tabled.
Okay, thank you. Yes, Dr. Bragg. Good. Now, fourth member for Port Louis North, Mr. Duval.
Yes.
B1144.
Yes, B1144.
Madam Speaker, I wish to inform the House that under Section 14 of the Higher Education Act, any institution that establishes itself in Mauritius and offers higher education courses is required to be registered with the Higher Education Commission before it can update or advertise programs locally. In regard to BHM International University, Spain, I'm advised by HEC as follows. BIU is not registered in Mauritius as a higher education institution. It has never submitted an application for registration to HEC. Consequently, it doesn't appear on the official register of the higher education institution maintained by HEC under the Act. Consequently, for overseas institutions that are not on the registered list established by HEC, HEC relies on the structured process for determining whether their qualifications may be recognized. First, the Higher Education Commission checks its database of overseas universities and institutions whose qualifications have been evaluated and recognized previously. If the institution doesn't appear in that database, then HEC formally consults the competent authorities in the country where the institution claims to be established, normally the National QA, Accreditation, or Higher Education Authority. In the specific case of BIU, I'm informed by the Higher Education Commission that it is neither registered in Mauritius nor it is on the existing list of overseas institutions already recognized by HEC. Consequently, HEC has written to the relevant Spanish authorities to seek formal confirmation of the legal status and recognition of BIU in Spain. At this point in time, the Commission is awaiting a written reply.
Yes. Now we have Mr. Seaburn.
Thank you, Madam Speaker. Is question 1145, please.
Madam Speaker, I would like to refer the Honourable Member to the replies I made to PQB 223 on 25th March 2025 and to PQB 616 on 8 July 2025, wherein I informed the House that the Flak Maibour B28 road had been severely affected following the pipelaying works undertaken by the Central Water Authority. The resurfacing works, which are currently ongoing along the stretch from Bambou-Verrier to Pointe du Diable, are being carried out by the CWA in accordance with the way leave conditions issued by the Road Development Authority to reinstate the road after the trenching and excavation works. Madam Speaker, the southeast regions, including Bambou-Verrier, Anse-Joncé, Bois des Amourettes, Vieux-Grand-Port, Rivière-des-Créoles, Petit-Bel-Air, and Grand-Bel-Air were declared by the Land Drainage Authority as high-risk flood-prone areas since April 2021. The study and implementation of flood mitigation measures in the region of Bambou-Verrier were entrusted to the National Development Unit in 2021. A preliminary design report for the flood mitigation measures in the Bambou-Verrier region was prepared by Servan Singh Jadhav and partners, consulting engineers, and submitted to the LDA in August 2022. Subsequently, geotechnical investigations were carried out along the proposed cut-off drain alignment in September 2023. Based on these findings, the consultant prepared and submitted a detailed design report, which was approved by the LDA in January 2024. The scope of works under the approved DDR includes the following. First, provision of cut-off drain 1 to 2 meters wide and 0.7 to 1.5 meters deep to intercept flows from the mountain slopes. Second, construction of a new culvert and upgrading of existing culverts along B28 road in Bambou-Verrier region. Third, raising and realignment of the B28 road. And fourth, upgrading of feeder Antoine, feeder Soukan, and Rivilé Bambou. Madam Speaker, regarding part A of the question, I am informed that in view of extensive land acquisition requirements, the following two projects along the stretch from Bambou-Verrier to Pointe du Diable were entrusted to the Drain Infrastructure Construction Limited in March 2024 for implementation. First, flood mitigation measures at Bambou-Verrier, and second, flood mitigation measures at Petit Sable and Grand Sable. Flood mitigation measures at Bambou-Verrier. I am further informed by DICL that the first procurement exercise for Bambou-Verrier project was launched on 3rd September 2024 through an open advertised bidding process. However, the exercise was not conclusive due to the high bid prices. Accordingly, the DICL board recommended that the bids be relaunched at a later stage upon securing financial clearance for a revised cost estimate. Funds for preparation of the project has been earmarked under the Climate and Sustainability Fund. The bid documents are ready. Once financial clearance is obtained for the revised cost estimate, the bidding exercise will be relaunched. As regards the project at Petit Sab and Grand Sab, DICL issued a works order in November 2022 to Servansing Jadhav and Partners Consulting Engineers Limited for inter alia the preparation of the bidding document. Geotechnical investigations were subsequently undertaken and the findings were incorporated into the DDR, which was submitted in May 2024, together with the LDS clearance. Following a technical meeting in July 2024, the draft bidding document and cost estimate were finalized, and subsequently in October 2024. However, under the Climate and Sustainability Fund, no funds have been earmarked in the current financial year 2025-2026 for the implementation of the project. Funds have been earmarked only for the preparation of the project, and as such, DICL cannot initiate the land acquisition procedures or launch the bids during this financial year. My ministry will make arrangements for funds to be made available for implementation of the projects in the next financial year. Madam Speaker, in parallel, the RDA has in the pipeline the project for the upgrading of the B28 road from Villenoir to Anse-Zoncé and from Anse-Zoncé to De Frères, which makes provision for the rehabilitation and construction of drains, culverts and bridges. The design for these sections had already been completed, and the RDA will submit the appropriate budgetary proposals in due course. In addition, the RDA has already completed the following: the construction of 4 culverts and slope stabilization works over a length of 200 meters under the project upgrading of B28 road from De Frères to Bel-Air, phase 1. Second, the construction of 4 culverts and 2 bridges under the project flood mitigation measures at Anse-Zoncé along B28 road. And third, the upgrading of existing roadside drains and the construction of new drains under the project upgrading of B28 road, lot 3 from De Frères to Bel-Air, phase 2. In the meantime, the RDA continues to carry out regular inspection to ensure the cleanliness and functioning of the existing drains along B28 road. A survey has already been completed, and works orders will shortly be issued to contractors under the framework agreement for cleaning, desilting and minor upgrading works.
Thank you, Minister. Yes, Mr. Brookley.
Madam Speaker, B1146.
Madam Speaker, I am informed by the Financial Services Commission that on average, the FSC receives around 2,400 global business companies' applications annually. As regards the date of submission of pending applications for GBCs, as at 15 November 2025, there are currently 120 applications pending, the oldest one dating back to April 2023. Madam Speaker, as regards part B of the question, I'm informed that it is for GBCs engaged in financial services activities that prior approval of the FSC is required for the appointment of or renewal of directors. The average time taken for the approval or renewal of directors is 14 days. As regards part C1 of the question, the FSC has received 62 complaints over the last 2 years for excessive delays for processing application of GBCs and domestic companies. Out of these complaints, 6 concern domestic companies and 56 concern GBCs. As regards part C2 of the question, I'm informed by the FSC that as at date, no formal complaint has been received in respect of delays in the processing of directors' appointment or renewals. Madam Speaker, the delays relating to licensing issues at the FSC underscores the need for continued improvement to strengthen efficiency and effectiveness. Since I took office a year ago, I have had extensive consultations with the industry stakeholders, and one of the most recurrent issue and problem that has come up are delays in processing of application. This clearly impacts on the ease of doing business and the competitiveness of the Mauritius International Financial Center. This is why in the Financial Services Strategy Report 2025-2030, ease of doing business has been recognized as one of the key 5 pillars. Madam Speaker, a new Chief Executive of the FSC has been appointed since September 2015. One of the key priorities of the FSC board and the new leadership is to improve the ease of doing business. The Chief Executive of FSC also chairs the subcommittee of the Financial Services Consultative Council, which has just been reconstituted. He chairs the Ease of Doing Business subcommittee of the FSCC, which reinforces the mandate and our drive to make improvements with regard to delays. I'm also informed that FSC has started implementing a series of measures, including upgrading of its application forms, and has embarked since November 2025 on the testing phase of a digital interface to make the process easier, clearer, and more efficient. The new modes of application contain enhanced features that guide applicants step by step, reducing mistakes and incomplete submission. In conclusion, Madam Speaker, I wish to say that timely processing of application is critical for the industry as we are competing globally. This is therefore a top priority for the FSC, and we are actively working on this. Thank you.
Thank you. Yes, Mr. Wilkie.
Madam Speaker, I must first of all thank the Minister for the very extensive reply. I would like to ask, in view of the 62 complaints received from management companies over the last 2 years, would she consider requesting the FSC to set up a special desk to handle complaints that is separate from the normal processes doing incorporations or applications?
I totally concur with the Honourable Member that we have already communicated to have a special desk, and also to communicate, to have a line of communication with clients, because very often clients are left without any communication.
Yes, Mr. Bijan.
Thank you, Madam Speaker. B1147.
Madam Speaker, I'm informed that the Beau Plateau Road is not a classified road, and as such it falls under the jurisdiction of local authority, namely the District Council of Rivière-du-Rempart. This road extends over a length of approximately 3.8 kilometers, and its width varies between 4 to 6 meters. As regard to party of the question, I'm informed that the project is currently at the conceptualization stage. Once all necessary clearances, including financial approval and those related to land acquisition, are obtained, the project will be implemented by the District Council of Rivière-du-Rempart. Madam Speaker, with regard to part B of the question, enlarging the road would, as stated earlier, require land acquisition, construction of retaining walls, pavements and drains, as well as provisions of handrails, modern poles, solar lanterns, and other associated infrastructural works, as rightly highlighted by the Honourable Member. The District Council of Rivière-du-Rempart has been requested to consult stakeholders and a technical committee to be set up accordingly.
Yes. Is that all right? Yes, okay. The Honourable Second Member for Audrey.
Thank you. B1148.
Madam Speaker, the Union des Fédérations de Football de l'Océan Indien was a regional football confederation for the Indian Ocean and operated under the African Football Confederation. Its main function was to organize football tournaments particularly for youth categories. It comprised 6 member associations, namely Mauritius, Madagascar, Réunion Island, Comoros, Seychelles, and Mayotte. Madam Speaker, l'Union des fédérations de football de l'océan Indien has been dissolved in October 2025, and a new organization, the l'Union des fédérations des îles et archipels, was established on the 9th November 2025 by the 6-member association, namely Mauritius, Madagascar, Réunion, Comoros, Seychelles, and Mayotte. Madam Speaker, with regard to part A of the question, I'm informed by the Mauritius Football Association that the Rodrigue Regional Football Association was never a member of the Union des fédérations de football de l'océan Indien. However, Rodrigue was invited as a special guest to participate in youth competition, namely under 15 boys and girls tournament in 2016 and 2017, upon the proposal of the Mauritius Football Association. With regard to Rodrigue forming part of the newly established union, the Fédération des Îles et l'Archipel, I'm informed by the Mauritius Football Association that for future tournaments, Rodrigue will be integrated within the selection of the Republic of Mauritius in line with national representation norms for future tournaments. I would like to point out that the Rodrigue Regional Football Association forms part of the Mauritius Football Association, just like the other regional football association and mainland Mauritius. Madam Speaker, with regard to part C of the question concerning Rodrigue's inclusion in the national plan for the relance du football, I would refer the Honourable Member to my reply to PQ B999 at our sitting on 11 November 2025. In accordance with the Sport Act 2016, Rodrigue is recognized as one of the 13 sport regions of Mauritius. Each sport region will benefit from the same program, support, and development initiatives under the plan, and Rodrigue will therefore be fully included in all future action to raise the level of our football to new height across the Republic.
Thank you. Yes.
Thank you, Madam Speaker. I thank the Honourable Member for his answer. May I ask the Honourable Minister whether he is aware if the new FFIOI Association adopted a new statute, and if he is in possession of same and he can circulate same in the interest of footballers. The new statute.
Under the plan of relance du football, Madam Speaker, including Rodrigue, will benefit from the same development measures. Like I said in my reply, the program includes infrastructure, upgrading, technical training, youth development, pathways, and regional competition. Rodrigue will therefore receive equitable support within the national framework.
Second and supplementary,
Yes,
Madam Speaker.
yes.
Madame la Présidente, Monsieur l'Honorable Ministre, pour l'avancement du football, en tant qu'ancien sportif moi-même, et meilleur athlète du deuxième de Rodrigue et ancien footballeur évoluant en première division rodriguaise, comme buteur. Buteur. J'aimerais bien demander à l'honorable ministre, serait-il disposé à militer ou à porter ou soutenir ou à même défendre auprès de la FIFA un projet sportif international venant de Maurice, de la République de Maurice, visant à organiser la Coupe du monde de football dédiée spécifiquement aux îles ou nations insulaires du monde entier.
Super.
I will take what the member has just said into consideration.
Very good. Very good. Yes. Honourable third member for Rivière-des-Anguilles.
Thank you, Madam Speaker. B1149.
Madam Speaker, I wish to inform the House that previously there was no angiography machine at Jawaharlal Nehru Hospital. It is now that the equipment is being installed and will be operational in the coming weeks. With regard to Part A1 of the question for the period 2020 to October 2025, I'm informed that 10,489 angiography cases were performed at Victoria Hospital. During the same period, 1,026 patients from Jawaharlal Nehru Hospital requiring angiography procedures have been referred to other hospitals. Madam Speaker, with regard to waiting list, I'm also informed that as at October 2025, there were 46 patients on the waiting list at Jawaharlal Nehru Hospital, whose waiting time of approximately 3 weeks, and at Victoria Hospital, there were 380 patients on the waiting list with a waiting time of 11 weeks. Madam Speaker, as regard Part A2 of the question, there are currently 5 angiography machines that are available in public hospitals, with one installed at Dr. Jitu Hospital, 2 at Cardiac Trust Fund for Specialized Medical Care, XXIX National Hospital, Pamplemousses, and 2 at Victoria Hospital. In addition, an angiography machine, which was left unutilized at Dr. Jitu Hospital, had been transferred to Jawaharlal Nehru Hospital. Moreover, with the setting up of cath lab services at Jawaharlal Nehru and Saj Hospital, the number of angiography procedures will definitely reduce the waiting time, thus relieving the suffering of our patients. Madam Speaker, with regard to Part B of the question, my ministry is resorting to extra sessions after normal working hours to curb down the waiting time for angiography procedures. In the meantime, training is being provided to paramedical staff in order to enable them to provide adequate angiography services. Madam Speaker, the House may wish to note that there has not been any action to provide angiography services at Jawaharlal Nehru Hospital for the past so many years, despite the fact that there was a Minister of Health from this particular region. Nothing was done to alleviate the suffering of the people in the southern part, and patients had to be referred to other hospitals. And adding insult to injury, our angiography machine donated by the government of Japan was left idle at Dr. Jitu Hospital for nearly 6 months and was eventually transferred to Cardiac Trust Fund, XXIX National Hospital, Pamplemousses. It's regretful that this machine could have been transferred to Jawaharlal Nehru Hospital, where optimum life-saving intervention could have been made to relieve the inhabitants of the southern region. In the meantime, training is also being provided to medical and paramedical staff to use the angiography machine at Jawaharlal Nehru Hospital. I wish to inform the House that one angiography machine will be installed at Clark Hospital in 2026. The procurement procedures have already been initiated for the acquisition of this equipment, which will provide a proximity service to patients in the eastern region.
Yes, Madam.
Thank you, Madam Speaker. Would the Honourable Minister consider the implementation or setting up of a formal framework with a view to developing and using an evidence-based system based on the clinical needs and urgency of patients?
Madam Speaker, all these things are being looked into. And I can even now announce by next year, the Rosebell Hospital will have additional departments, including one renal department, which is being provided by the Government of India. And also there will be, apart from this, there will also be other operations, surgical operations which will be conducted, including even lung surgery.
Lung surgery. Lung. Yes. Okay, you all right? Mr. Bijan? No? I'm sorry. Mr. Seaburn.
Thank you, Madam Speaker. It's question B/1150, please.
Madam Speaker, I'm informed that the National Development Unit proceeded with the upgrading of the Bois des Amourettes football ground in 2 phases as follows. Phase 1, upgrading of the Bois des Amourettes football ground, which comprised the returfing of the whole pitch, and Phase 2, upgrading of the frontage fencing of the Bois des Amourettes football ground. Madam Speaker, for Phase 1, the contract was allocated to Sotrafic Limited on 17 February 2023 for an amount of 6,715,349.80 by the NDU under its framework agreement for amenities. The scope of works included the following: excavation of 700 mètres cubes of existing topsoil, provision of 1,050 mètres cubes of imported fill for returfing works, supply of 600 mètres cubes of vegetable topsoil, provision of 135 mètres of French drains around the area of the football pitch, supply and placing of 2125 mètres cubes of spoils of size 200-300 mm in size, felling of 4 trees, and supply and planting of grass Chien-dent of an extent of 4250 mètres carrés. Madam Speaker, as regard to phase 2 of the project, the NDU awarded a second contract to Sotravic Limited on 30 January 2024 for an amount of 4,113,109,55 under its framework agreement for amenities. The scope of work concerned the upgrading of the frontage fencing, which consisted of demolition of existing block wall over a length of 84 meters, excavation and laying of blinding concrete, construction of a new 1 meter high block wall fencing with 4.5 meter high galvanized metal fencing over a length of 84 meters, remedial works to damaged turfing of football ground, and provision of a new main gate 4 meter wide and 1 pedestrian gate. Madam Speaker, the final handing over exercise to the District Council of Grand Port for phase 1 and phase 2 of the project was carried out on 16 January 2025. I'm informed that snags were identified during the handing over exercise. The discrepancies identified were leveling of the topsoil, presence of pebbles, and maintenance of grass turfing, which were not to adequate lengths. Madam Speaker, follow-up was done through monthly site visits by the NDU and the contractor Sotravic Limited to review the status of the remedial works. On 21st October 2025, the final handing over was carried out successfully after all remedial works were cleared by the contractor and the site was taken over by the District Council of Grand Port. Madam Speaker, I'm further informed that during a site visit carried out by the 3 MPs of the constituency, together with representatives of the District Council of Grand Port and the contractor on 19 November 2025, it was observed that the football ground was uneven and there were presence of pebbles on the pitch. Madam Speaker, I have also been informed that during the Regatta Festival held from 29 to 31st August 2025, the football pitch was used to park vehicles, which I understand damaged the playground. I would here seize this opportunity to inform the House that henceforth football grounds would not be used as parking space, but only for the specific purpose for which it is meant for. Madam Speaker, being given that the football ground is now contractually under the responsibility of the District Council of Grand Port, the latter has been requested to carry out the remedial works. Madam Speaker, as for part B of the question, the football pitch will be operational once all remedial works are completed by the District Council and the ground certified fit for use.
Yes, Mr. Auriaro. 5-1.
Madam Speaker, let me at the outset state that when we look at the evolution of reputable international arbitration centres worldwide, there has been no magical wand employed to propel them to the place of respect that they currently enjoy. Their current status has been the result of enduring, consistent, and incremental strategies developed and adapted over the years. I have to say that governments hosting reputable international arbitration centres have been very careful in giving support to these centres to avoid a direct interventionist approach that runs counter to the very spirit of neutral, independent resolution of disputes. In these successful ventures, governments have been mere catalysts, leveraging on the invaluable input of their private sector. The examples I have in mind are the Singapore International Arbitration Centre and the Hong Kong International Arbitration Centre. Hong Kong one was established in 1985, the Singapore one in 1991, and it took both of them a number of years to flourish into the respected arbitration centres that they now are. In Mauritius, we started our international arbitration venture in or about 2008 with the enactment of the International Arbitration Act based on the UN Citral model law. This was followed by the establishment in Mauritius in September 2010 of the first office of the Permanent Court of Arbitration outside The Hague, with the Secretary General of the PCA having the functions of appointing authority for the arbitral tribunal. Subsequently, the Mauritius International Arbitration Centre, the MIAC, was set up in 2011 as a fully owned government company and operated as a joint venture with the London Court of International Arbitration until 2018. I'm informed that towards the third quarter of 2018, MIAC continued its operation with support from the PCA under a management agreement. In 2019, MIAC and PCA, originally housed in Neban, migrated to new premises in Kudan with a state-of-the-art arbitration suite and of international standard. I'm informed that MIAC and the Mauritius office of the PCA have been involved in increasing the visibility of Mauritius as an international arbitration jurisdiction by participation in various international arbitration events. I am also informed that MIAC has signed numerous cooperation agreements with prominent international arbitration institutions, including the International Centre for Settlement of Investment Disputes. I'm further informed that the PCA continues to administer an increasing number of cases through its Mauritius office, and that this year marks the 15th anniversary of its establishment in Port Louis, a milestone celebrated with the participation of the Honourable Prime Minister, the Minister of Foreign Affairs, myself, members of the Judiciary and the Bar Council. The presence of the Secretary General of the PCA on this occasion testifies to the importance attached by the PCA to its partnership with Mauritius. The years post-2016, Madam Speaker, also saw a transformation in the structure of the MCCI Mediation and Arbitration Centre, commonly known as MARC, with increased emphasis on international arbitration. I'm informed that MARC has also hearing facilities of high international standard. Moreover, as announced by the Honourable Prime Minister, Government is presently working with the Mauritius Chamber of Commerce and Industry towards the consolidation of alternative dispute resolution services in Mauritius through the prospective merger of MIAC and MARC. I have not later than yesterday, Madam Speaker, engaged with the MCCI to push through this matter so that it becomes reality in the next few months. In fine, Madam Speaker, in parallel with these institutional developments, sustained efforts have also been made to build domestic capacity in international arbitration. I'm informed that the PCA Mauritius Fellowship Programme, in place since September 2016, provides for the annual employment of a young Mauritian lawyer at the Permanent Court of Arbitration for 1 year, thereby contributing to the development of local expertise. Furthermore, various trainings, lectures, conferences, and other knowledge-sharing initiatives are regularly undertaken by the PCA, MIAC, and several Mauritian organizations involved in dispute resolution. These capacity-building measures have strengthened the local arbitration ecosystem and contributed to Mauritius being consistently regarded as a safe seat for arbitration, as reflected in reputable international assessments such as the Delos Guide to Arbitration Places. In fine, Madam Speaker, Mauritius has over the years developed all the necessary bases to be a reliable, suitable and efficient international arbitration jurisdiction, starting with a law-based UNCITRAL model law, then with credible arbitration institutions with recognizable rules of international standard, and finally with state-of-the-art hearing facilities. Finally, making Mauritius a beacon for international arbitration in the region does not boil down to inventing new measures, but to first rationalizing and capitalizing on what we already have. Government fully realizes the potential that exists in international arbitration and is, without being unduly interventionist, determined to explore and facilitate the creation of appropriate channels to leverage on the goodwill we have already acquired in the field of international arbitration. But this has to be done in, as I said before, an incremental fashion, whilst giving full and careful consideration to the needs of the moment.
Thank you. Thank you, Minister. You're right. Honourable Second Member for Belrose-Quatre-Bornes.
Je vous remercie, Madame la Présidente. 1152.
Madam Speaker, I wish to draw the attention of the Honourable Member that L'Oiseau du Paradis shelter has been closed down since the 5th of June 2025, following an incident which occurred on the 1st of June 2025 when 3 minors absconded. A rapid drug test was conducted on the minors, which revealed positive results for cannabis in 2 children, while the 3rd child was tested negative. As regards Part A1 of the question, the residential care institution, the RCI, can accommodate a maximum of 30 boys aged between 5 and 17 years old. Regarding Part A2 of the question, 33 caregivers, 2 general workers, 3 cleaners, and 2 cooks employed by the National Children's Council have been redeployed to Cap l'Espoir in Cap Malheureux as from 1st December 2025, that is yesterday. In addition, a shelter manager has been appointed by the board of the National Children's Council and will take office as from tomorrow. As for Part B of the question, it is envisaged that the residential care institution of Cap Malheureux will resume operation as from 4th December 2025, and my ministry will ensure that the RCI adheres to all safety and regulatory standards of the RCI for Children Regulations 2022. My ministry has a dedicated team of enforcement officers who will conduct regular visits at the RCI to ensure that it is fully compliant with the safety and regulatory standards. Madam Speaker, the shelter is currently undergoing renovation works comprising painting, installation of burglar-proofing to openings, replacement of ceramic tiles, among others, following a tender exercise. Work started on the 15th of November 2025 and will be completed by Wednesday, 3rd December 2025. I wish to inform the House that yesterday all staff turned up, except 6 who were on vacation and casual leave. I wish also to point out that the child caregivers have been provided with training on child psychology and on legal matters in November 2025 by senior officers of my ministry in collaboration with Pedostop, a registered NGO. Continuous training will be dispensed to the staff working at the shelter to equip them with the required skills in carrying out their duties.
Yes, allez-y.
Je vous remercie, Madame la Présidente. Je remercie la ministre pour sa réponse. On comprend qu'un maximum de 30 enfants seront placés dans cet abri sous la responsabilité du même personnel qui l'a rendu tristement célèbre. La ministre peut-elle informer la Chambre si c'est ainsi qu'elle entend professionnaliser cet abri et donner l'assurance que les mêmes dérives ne se reproduiront pas? Merci, Madame la Présidente.
Madame la Présidente, j'ai répondu que les caregivers ont eu la formation nécessaire pendant le mois de novembre de par nos officiers du ministère et l'ONG Pedostop. J'ai rencontré les caregivers personnellement. Ils m'ont assuré que leur mindset a changé. Donc je compte sur eux. Il y a toujours est-il, Madame la Présidente, qu'il y a 25 personnes, 25 employés qui sont suspendus, qui ont été suspendus de juillet 2018 à ce jour. Donc, nous comptons recruter ces personnes-là au fur et à mesure.
D'autres personnes. Vous voulez recruter d'autres personnes?
Non, on va, allons dire, réintégrer ces personnes suspendues. The case will be taken on a case-to-case basis by the board of the National Children's Council after all charges have been cleared against these persons.
Deuxième, je vous remercie, Madame la Présidente. Pour éviter les dérives du passé, La ministre peut-elle indiquer à la Chambre si elle considère que 2 demi-journées de formation en psychologie et 1 journée sur le droit des enfants en 6 mois de fermeture suffisent à redresser un abri pour sa gestion chronique défaillante? Je vous remercie, Madame la Présidente.
Certainement pas, Madame la Présidente. C'est pourquoi, dans ma dernière phrase, à la question, j'ai dit « Continuous training will be dispensed to the staff working at the shelter ». Donc, la formation sera continue.
Oui, Madame Savapati.
Merci, Madame la Présidente. Est-ce que la ministre peut nous dire quelle garantie que nous avons que le mindset va changer? Merci.
Je n'ai aucune garantie, Madame.
Vous avez encore une question?
En fait, j'ai encore 2, mais je ne sais pas si vous allez me permettre. Vous savez, Madame la Présidente,
C'est un sujet tellement important. Je vais vous
ces
permettre.
enfants ne méritent pas l'indifférence. Ils méritent dignité, sécurité
Pas de commentaires.
et tout.
Question.
Non, mais c'est ça, je dis, si vous me permettez. Alors, la ministre peut-elle expliquer pourquoi le problème d'égout situé dans la cour de l'établissement, à proximité de la cuisine, et qui nécessite l'intervention des camions de Siven pour le pompage des toilettes toutes les 2 semaines, persiste, et si un tel manquement est compatible avec les normes de santé et de sécurité applicables aux enfants en accueil résidentiel. Je vous remercie, Madame la Présidente.
Madame la Présidente, j'ai dit dans ma réponse qu'il y a des works which are going on et tout sera réglé dans les meilleurs délais.
Dernière.
Vraiment une dernière. Alors, vous savez, Madame la Présidente, sous l'Ancien Régime, ma demande de visiter l'oiseau du paradis par un groupe de parlementaires des 2 côtés de la Chambre avait été refusée. La ministre peut-elle indiquer si cette fois-ci, elle accordera l'accès à l'abri à un petit groupe de parlementaires des 2 côtés de la Chambre? Je vous remercie, Madame la Présidente.
Certainement, Madame la Présidente.
Très bien. Monsieur Roukni, vous aviez une question? Ah, j'ai cru voir votre main. Ah, c'était pour dire bonjour. Très bien, l'oiseau du paradis. Espérons que ce sera le paradis, Madame la Ministre. Alors, maintenant, nous avons Monsieur Roukni. Ah, c'était pour ça.
Madam Speaker, B 1154.
Madam Speaker, allow me to reply to this PQ on behalf of the substantive Minister of Agro-Industry, Food Security, Blue Economy and Fisheries. The Division of Veterinary Services of my ministry issues permit for import of frozen, chilled, ambient and dry meat products from several countries including Australia, New Zealand, France, Ireland, South Africa and India. With regard to part A of the question, I wish to inform the House that for the last quarter of 2024, around 2,300 goats, 2,650 sheep, and 1,181 cattle were imported from South Africa. For the last quarter of this year, the Division of Veterinary Services has already issued import permit to Sokovia, Bellevue Limited, for importation of 3,000 goats, 3,000 sheep, and 994 cattle from South Africa. 649 cattle reached on 21st November 2025, while 3,000 goats, 3,000 sheep, and 345 cattle are expected to land on the 3rd December 2025. The Commission of Agriculture, Rodrigues Regional Assembly, has informed my ministry that a quota of 1,150 livestock, including 800 goats and sheep, will be made available for the final quarter of 2025. Furthermore, I'm informed by the Food and Agricultural Research and Extension Institute that around 4,500 goats and 100 sheep are estimated to be potentially available from local farmers in December 2025. Madam Speaker, with regard to part B of the question, I wish to inform the House that I have received assurance that there will be no substantial increase in the price of cattle, goat and sheep during the forthcoming festive season. Furthermore, my ministry will set up a monitoring committee with the representatives of the Ministry of Commerce and Consumer Protection, the Mauritius Meat Authority, the importers, and the Association of Butchers, with a view to ensuring that the price of meat remains stable and affordable for the festive season. As regards Part C of the question, in line with the decision taken by government on 24th October 2025 to have recourse to 100% non-structural protein ELISA test and 10% solid phase competition ELISA test on livestock imported from South Africa due to the foot and mouth disease, it is expected that the additional testing costs incurred by the importer will be absorbed in the overall pricing structure, resulting in no significant increase in retail price and no disruption in the supply of meat. Madam Speaker, in addition, with the number of livestock being imported, the quota submitted by Rodrigues Regional Assembly, and the availability on the local farms, it is expected that there will be no shortage of meat during the festive season. Thank you.
Thank you, Minister. Mr. Olty, you're okay. Okay, now we have second member for Quartier Militaire, Madame Tanou.
Apologies, it has been withdrawn as well.
Okay, it's all right. I'm getting used to this. The Honourable second member for Grand Bay Poudre d'Or, Mr. Bijan.
Thank you, Madam Speaker. B1156.
Madam Speaker, the building in question doesn't fall under the responsibility of my ministry. I am fully aware of the difficulties faced by the inhabitants of Goodland, Rousté, Grand Group, and Chirafri and surrounding areas who currently have to travel to Rivière du Rempart to obtain cremation and burial permits. I wish to inform the House of the Prime Minister's Office, the Ministry of Local Government and my ministry will look into providing a single point office in Goodlands for the issue of burial and cremation permits.
Alors, okay? Let me tell you, otherwise I'm completely confused. Now, the table has been advised that the following PQs has and have been withdrawn. B1159, coming soon. B1171, 1157, also coming soon. 1173, 1166, 1160, and 1164. I am saying once more, we must find a better solution to this. It gets very confusing after a while. Okay, let us go on. If I make a mistake, you just tell me. So, Mr. Bijan, you're okay? Okay. Now we have Mr. Kazan. It has been withdrawn. 11, yes, I just mentioned it. 57, okay. Je vais essayer de me retrouver dans tout ça. Je ne vais pas dire un mot méchant. Alors, Ms. Dawi Arouigan.
Speaker B1158.
Madam Speaker, Chateau Benares, located in the district of Savanne, was designated as a national heritage on 6 May 2022 in view of its historical significance. Although it is a national heritage, it is vested in the District Council of Savanne, and any restoration works have to be undertaken by the latter organization under the supervision and technical guidance of the National Heritage Fund. Madam Speaker, I am informed that officers of my ministry and the National Heritage Fund have carried out several site visits in the past, during which advice was duly provided to the District Council of Savanne. Since 2023, an architect and an engineer employed by my ministry under the Expert Skills Program have been conducting surveys thereat, and a preliminary report, together with recommendations to, inter alia, recruit a specialist with experience in the restoration of heritage building were made. With regard to Part A of the question, I am informed that in view of the prevailing economic situation, the project has been placed in abeyance by the District Council of Savanne. With regard to Part B and C of the question, I am informed that since the project has been put in abeyance, no contractor has been appointed. As such, no start and no completion dates have been set up. Thank you.
Yes? You're okay? All right, so now we don't do 1159. We go to Dr. Prayag. First member for Pito, Rivière du Rhum. Yours has also been...
Has been withdrawn, madam.
Also, okay. Honourable First Member for La Caverne Phoenix, Mr. Lobby.
E1161, please.
Madam Speaker, concerning Part A of the question, I am informed by the Registrar of Cooperative Societies that since 2018, the National Transport Corporation Employees Cooperative Credit Union Limited has undertaken a restructuring of its capital to adapt to changing economic conditions. To that effect, members' share capital was transferred to a deposit account, while a minimum share of 100 rupee was maintained for each member. Since then, payouts to members have been in the form of interest on deposits instead of dividends on shares. It has been reported that at the annual general meeting of the National Transport Corporation Employees Cooperative Credit Union Limited, held on the 12th of July 2025, the Assembly unanimously approved the payments of interest on deposits for the years 2022, 23, 24 as follows. For year 2022, on a deposit of 30,912,986 rupees, interest of 1,174,693 rupees to be paid at the rate of 3.8%. For the year 2023, an amount of 614,789 rupees to be paid as interest to the rate of 2% on a deposit of rupees 30,739,448 rupees, and an amount of 787,246 rupees to be paid as interest for the year 2024 at the rate of 2.45% of a deposit of 31,489,859 rupees. An amount of 1,339,322 was credited to members' individual bank accounts, and 1,237,407 rupees were transferred to members' deposit accounts as per their wish. Madam Speaker, as regards to Part B of the question, I am informed that a petition was received from the members of the National Transport Corporation Employees Cooperative Credit Union Limited, requesting the removal of the caretaker board and to proceed with democratic election of members. Accordingly, my ministry had approved the removal of the caretaker board on the 19th August 2025 and has authorized the Society to proceed with the election of a democratically elected board in accordance with Section 41(3)(d) of the Cooperatives Act 2016. Concurrently, my ministry sought the advice of the State Law Office on the eligibility of members of the Society who were previously in the elected board as to whether they could stand for re-election. The Solicitor General has, in a letter dated 14th November 2025, highlighted that in two reports from my ministry dated 11 December 2015 and 28 July 2025, respectively, it was observed that funds have been misused and mismanaged. The Solicitor General has thus advised that pursuant to Section 48G of the Cooperatives Act, all members of the previous board who were subject to reports would not be qualified to stand as candidates for the post of director in the upcoming election. Madam Speaker, the Society has recently been informed of the advice of the Solicitor General about the ineligibility of members who were reported for misuse and mismanagement of funds to stand as candidates for the forthcoming elections.
Yes, all right. Thank you. Yes. Honourable First Member for Port Bruce North.
Thank you, Madam. Question B1162.
I wish to inform the House that statistics show that there has been an increase in the percentage of C-section carried out in both public and private health institutions from 46.3% in 2015 to 61.4% in 2024. I am also informed that the age group 20 to 34 years have recourse to C-section and is following the same trend during the last 5 years. With regard to part A of the question, according to latest figures of the 2024, out of 8,052 total births in public hospitals, the ratio of normal delivery to C-section is almost 1:1, whereas in private health institutions for 2024, out of 4,103 total births, the ratio of normal delivery to C-section is 1:2. Madam Speaker, with regard to Part B of the question, in line with World Health Organization's recommendations, my ministry is implementing several measures to reduce the need to carry out C-section deliveries, amongst others. 1. Preconception care counseling is conducted regularly by community health care officers in the community. 2. Women are encouraged to plan and space their pregnancies through the use of contraceptives provided free of charge in family planning clinics. 3. Antenatal care is provided as early as possible in primary health centers and include one-to-one and group counseling, echographies, and vitamins and iron supplementation. 4. High-risk cases and teenage pregnancies are referred to regional hospitals for specialized follow-up by obstetricians. 5. Labor wards are fully equipped to ensure cardiotocographic monitoring of labor and fetal heart rate to prevent complications during labor. 6. Decision to conduct a cesarean section are based on clear indication. 7. Other measures include capacity building of health professionals involved in maternal and child health based on updated national obstetrics protocols. Madam Speaker, through these measures, the Ministry remains committed to ensuring that every cesarean section is performed for the right reason, at the right time, and in the right setting, thereby aligning national practices with international best standards. Cesarean section is absolutely critical to save lives. In situations where normal deliveries would pose a risk, such as malformations of fetus, hypertension in pregnancy, maternal complication, gestational diabetes mellitus, fetal distress, or due to baby's malpresentations. According to new research from World Health Organization, births by cesarean section continue to rise globally, now accounting for more than 1 in 5, that is 21% of all childbirths. This number is set to continue increasing over the coming decade, with nearly a third of 29% of all births likely to take place by cesarean section by 2030. Mauritius is also following the same international trend regarding the increase in cesarean section deliveries. There are so many other reasons accounting for the increased number of cesarean section deliveries, to name a few. Number 1, increasing maternal age and numbers of multiple births. Number 2, higher rates of obesity among women. Number 3, a lot of previous cesarean pregnant ladies required to be sectioned. And number 4, increased number of sexually transmitted diseases. My ministry is also proposing to take the following additional measures to address the issue of increasing cesarean rate. Number 1, clinical audit and monitoring to assess whether indications are being undertaken in public hospitals to ensure medical justification and adherence to WHO guidelines. Number 2, updating and standardizing national protocols to emphasize evidence-based management of labor and delivery, including use of WHO Robson classification system to monitor and compare CS rates between facilities. Number 3, organization of continuous medical education and refresher courses for obstetricians, midwives, and labor ward staff to strengthen decision-making during labor management and promote safe normal deliveries where feasible. Number 4, strengthen antenatal counseling on normal delivery. Number 5, public education campaign to highlight that vaginal delivery remains the safest options where no medical contradictions exist.
Yes.
Thank you, Madam Speaker. Can the Honourable Minister inform the House whether any study has been carried out how Mauritius is affected as compared to other countries in the SADC region? Thank you.
Well, Madam Speaker, I don't have any information regarding such type of studies which have been carried out. But of course, as I have already mentioned, this is a international trend, and I do hope that with the measures that we have taken, we can I don't say an end, but rather a break to this system, which is in fact not normal.
Thank you, Madam. My second question is, why is that the cost of CS by public institutions is less than those performed by private institutions? Has this also been looked into, Honourable Minister?
Sorry, I missed the last part. Are you saying there are more in public hospitals?
No.
No, it's the contrary.
Yeah.
Yeah, but it is still a lot. Yes.
But if you compare with public hospitals and private hospitals, you find in public hospitals it's less. The number of cesareans compared is less than in private hospitals. Probably prosperous people go in the private hospitals.
So it's a question of money.
Maybe that they want to get the best way out. That may be one of the reasons.
Don't say that, Minister. The best way out? Don't say that.
I mean to say now, well, I'm not an expert in that field, but I get the feeling, that they want really the easiest way instead of going under the pains and all.
La facilité, on appelle ça la facilité. Okay, let her finish.
My last, thank you,
Of
Madam.
course.
Can the Honourable Minister provide us some statistics? Thank you.
Oh, of course, with pleasure. I'm going to provide this. That is the detailed statistics I'm going to provide.
Yeah, please lay it on the table.
I'll lay on the
It's
table.
such an important issue.
Yeah,
And you know that it's dear to my heart. Yes,
Thank-
Dr. Praya.
Thank you, Madam Speaker. Thank you, Honourable Minister. While providing the statistics, I think it would be more informative to us if we could have been provided the statistics of elective normal deliveries and elective cesarean sections as compared to public and private, and separately comparison of emergency vaginal deliveries and C-sections in public and private. Then we might be able to really compare how much insurance companies come into the game here.
I know your interest in this subject. I'm going to provide you a bulky
Yes.
document on this. All the details will be provided. I'll take some time.
Thank you so much, Minister.
Yes, thank you, Madam Speaker. May I ask the Honourable Minister whether he has any information or statistics about caesarean section prevalence for Rodrigues, or what is the actual situation there, if any?
Yes, Madam Speaker, I expected a question from Rodrigue. For the period of 2020 to 2025, the last 5 years, out of 4,929 births in Rodrigue, 1,938 babies were delivered by CS, which corresponds to most 39.3% of the overall births. Statistics indicate that over the past 5 years, there is an increase in the number of CS performed. In 2020, it was 38.1. Now it is 43.3% 2025. So even Rodrigue needs some special attention.
En français, on dit la naissance par le bas. Non, c'est vrai. On a appris ça, là, récemment. Okay. It seems that I have more questions that have been withdrawn. B1165 and 1168. It's normal because now time is over. Thank you very much, Minister, and everybody. We break for tea. Yes? You want to say a
Yes,
word?
Madam Speaker. No, I move now.
Yes.
I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Thank you.
Yes, the question is that all the business of today's paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye. Aye. Yes, those against say no. Okay, so now we break. Oh, I thought we were breaking for tea. No? No. Oh, I'm sorry. It's just that, I'm sorry. It's just that time is over for questions. Honourable Attorney General, I suppose that's what
I'm afraid it's not my turn yet.
It's not yet your turn. Je suis inondée de documents. J'ai plus accès à l'essentiel. Allez.
Statements by ministers, none. Public bills, first reading.
Now, public bill.
Yes, Madam Speaker, I move that the Road Traffic Amendment Bill be moved be read the first time. Thank you.
Yes. Seconded. It is seconded. Yes, Minister. Okay, now second reading.
Madam Speaker, I wish to inform the House that I do not propose to proceed with the Law Practitioners Disciplinary Proceedings Bill number 24 of 2025, and that notice has already been given to the Clerk of the National Assembly as far back as the 18th of November. I therefore move that the Law Practitioners Disciplinary Proceedings Bill number 29 of 2025 be read a second time.
Yes, and who's? Okay, you carry on, carry on.
Madam Speaker, the Law Practitioners Disciplinary Proceedings Bill is a reform that goes to the heart of the confidence that our citizens place in the legal profession and, by extension, in the administration of justice itself. Legal practice is not merely a technical craft. It is surely not a business. It is a vocation rooted in trust. The bill recognizes that truth. It seeks to protect the overwhelming majority of practitioners who serve honorably whilst dealing firmly and transparently with the minority whose conduct undermines that trust. Let me state at the outset what this bill does not do. You see, Madam Speaker, I stand here as a member of that profession for 40 years, a profession that I love and made me who I am, a profession that I share with colleagues whose work and ethics I admire. I know that most practitioners work with dedication, often unseen and unacknowledged. But we also know, because the public and the press regularly remind us of this, that this confidence has been weakened by a perception that misconduct is not always dealt with swiftly, visibly, or consistently. I regularly receive visitors at my office. They are from all over the country, from all ages. Some come with their documents, neatly compiled over the years, some with just a handwritten note, their desperation poured on paper. They want help. They think the Minister of Justice, as they often mistake the Attorney General to be, is the one they should turn to because they feel the system has failed them. They don't understand why their plot of land is still disputed after many years, or why the courts have not struck down this deed of sale which they say is fabricated. When it is explained to them what the Attorney General's office does and why it is better that they turn to their legal advisors for such matters, it is then that the story has come out. Madam Speaker, again we are talking about a handful of rotten apples, but the acts and omissions of these legal practitioners besmirch the whole profession. Often enough, fortunately, complaints will be unfounded, but even then, the perception of the public is that their accusations have not been dealt with efficiently or transparently. A few cases, a few repeated complaints, a few unresolved matters, sometimes that is all it takes to erode the standing of an entire profession. Madam Speaker, this bill is therefore not an act of suspicion. It is indeed an act of faith in the profession and an act of responsibility towards the public. It is an expression of confidence that the reputation of law practitioners is worth protecting, that the best way to defend the honor of a profession is to ensure that its disciplinary framework is fair, independent, transparent, and effective. Before explaining the architecture of the bill, it is important to reflect on why this necessary reform has taken this particular shape. For more than a century now, the system of self-regulation has prevailed. It has served us in some respects, but it has also shown clear limits. The more so in recent years, with the rapid increase in the number of law practitioners. We are now almost 1,600 barristers on the roll of barristers in Mauritius. We are not talking of attorneys and notaries. The Bar Council, the Chamber of Notaries, and the Law Society have all exercised disciplinary oversight over their members, and they have done so conscientiously. However, the system as a whole has not delivered the consistency or transparency that a citizen can expect in this 21st century. Complaints accumulate, some remain unresolved for years, some are closed or remain in limbo in ways that arouse suspicion. From the outside, observers conclude, rightly or wrongly, that lawyers cover for lawyers. This perception, fair or unfair, weakens the legitimacy of the profession and of the justice system itself. The government program has made accessibility and efficiency of justice clear priorities, and credible disciplinary proceedings are part of that mission. Madam Speaker, we did not embark on this reform lightly. Even though the previous draft bill had received the approval of Cabinet, I decided to go back to the drawing board after having listened and heard the qualms of law practitioners. We held lengthy consultations with all stakeholders, the Bar Council, the Law Society, the Chamber of Notaries, senior practitioners, young practitioners, and members of the judiciary. And this, it must be said, built on past feedback of previous draft versions of this bill, elaborated under the previous government. They did seek to tackle the subject, but when met with serious objections, they lacked the ability to self-examine, compromise, and improve. Since there was no political will, there was no change. Today we have a government with a clear political will and which will bring this much needed change. As I said, our consultations were substantive, intense. Many provisions of the bill have been modified to reflect the concerns and suggestions of the professions. But on one point, the insistence of maintaining self-regulation, we could not compromise. Independence is essential. A disciplinary system must not only be fair, it must be seen to be fair. Madam Speaker, allowing the profession's exclusive disciplinary authority no longer meets that standard. Still, I wish to emphasize that the professional bodies retain a key voice in the new Commission. They nominate and are part of the decision-making process of appointment of members. They contribute expertise and they participate in all divisions. Their role is significant, though no longer exclusive. My attention was recently drawn to the fact that some law practitioners would have been perceived to have meddled in unsavory matters and could well become members of the Commission because the seemingly sole criteria is the fact that he or she has spent 15 years in the profession. My short answer is this. Although the possibility, however remote, does exist, we must, however, foster the belief that all three heads of the three professions and the Attorney General of the day would surely not fail in their duty to ensure that those appointed are beyond reproach, and this without a shadow of a doubt. I am those who firmly believe that our professions are teeming with good, honest practitioners who like to hold their head high. I trust that 4 of the most senior members of the profession will never stoop so low as to choose someone with an unenviable track record to sit on the Complaints Commission. That being said, allow me, Madam Speaker, to walk the House through the main mechanisms of the bill, beginning with the establishment on composition of this new body, the Complaints Commission. Now, Clause 4 of the bill establishes that commission as an independent statutory authority empowered to receive, investigate, and determine whether disciplinary proceedings should be initiated. It is expressly insulated from the directional control of any person or authority. Clause 5 proposes that it be composed of a chairman, 2 vice chairs with senior judicial or professional experience, as well as 9 members nominated respectively by the Bar Council, the Law Society Council, and the Chamber of Notaries. This ensures both independence and expertise. The creation of the appointment committee here is the precise result of the feedback we received from the professional bodies. There was a fear that an appointment process resting exclusively in the Attorney General could transform this body into a controlling device of the exercise of the executive over law practitioners. That had not been the intent of our first version, but the professional bodies pointed out that future abuses by less scrupulous people could not be ruled out. They were right, and we listened to them. The structure of divisions in the Clause 6 reflects the specificity of each branch of the profession. Complaints against barristers are heard with 2 barristers sitting with a chair or vice chair, similarly for attorneys and notaries. In doing so, the bill ensures that standards are judged by those who understand the professional context, whilst avoiding the shortcomings of self-regulation. It is a balanced solution which fits the bill. The procedure for opening complaints is set out clearly in Clause 8. Any person, including members of the public, judicial officers, the Attorney General, the professional bodies, may lodge the complaint. It must normally be filed within 6 months, though the Commission retains the discretion to entertain serious complaints even if late. Importantly, the Commission may also initiate investigations proprio motu, that is, as you know, Madam Speaker, of their own initiative. Now, to avoid abuse, Clause 9 gives the Commission power to dismiss complaints that are trivial, frivolous, or vexatious. Where matters are minor or stem from misunderstandings, Clause 10 empowers the Commission to attempt conciliation. This allows resolution without stigma and avoids unnecessary escalation. When an investigation is warranted, Clause 11 sets out the process, written explanations, summoning of witnesses, compulsory production of documents, even recourse to the judge in chambers where confidentiality is invoked. Investigations must be completed within 90 days. This is an important guarantee of timeliness and fairness. A staple inclusion now in the processes that this government is shaping for the justice system of this country. In cases of minor misconduct where the practitioner has no prior record, Clause 12 allows the Commission to administer a caution, a proportionate measure that protects the public interest without imposing excessive sanctions. The Chief Justice, Attorney General, and the relevant professional bodies are then duly notified. When there is no evidence of misconduct, Clause 13 requires written notification to all parties with reasons, including the complainant, of course. This protects practitioners from the reputational harm of unsubstantiated complaints. If, however, the Commission finds a prima facie case, Clause 14 mandates that it refers the matter to the Supreme Court after obtaining the Solicitor General advice on the formulation of charges, and the Supreme Court then becomes the sole disciplinary authority. This, Madam Speaker, is a point worth emphasizing. Case law, such as that of Gimel, has firmly established that the disciplinary function of the Supreme Court over law practitioners are part of its inherent powers. That is, powers that, even when they are not expressly provided for, are necessary to the good functioning of its judicial mission. The principle relating to the retention by the colonial courts of their powers of discipline over barristers and the rationale behind it having been succinctly explained by Lord Denning in the Gambia, which was referred to with approval in the case of Gimel in Mauritius, and I quote, "By the common law of England, the judges have the right to determine who shall be admitted to practice as barristers and solicitors. and as incidental thereto, the judges have the right to suspend or prohibit from practice. In England, this power has for a long time been delegated, so far as barristers are concerned, to the Inns of Court, and for a much shorter time, so far as solicitors are concerned, to the Law Society. In the colonies, the judges have retained the power in their own hands, at any rate in those colonies where the profession is fused. Now, advocates and attorneys have always been admitted in the colonial courts by the judges, and the judges only. The power of suspending from practice must, we think, be incidental to that of admitting to practice, as is the case in England with regards to attorneys. In Mauritius, as we all know, barristers, attorneys and notaries are admitted to practice by the Supreme Court, and only the Supreme Court can therefore decide on eventually removing them. We have thus preserved this principle here. The Commission investigates, but it is the Supreme Court that decides. This disciplinary process before the Supreme Court is addressed in Part 3 of the Bill. So Clause 15 dictates that the court sits as a disciplinary tribunal composed of 2 judges, hearing the matter in open court except for justified exceptions. Clause 17, the court may dismiss the charge, reprimand the practitioner, suspending, striking him off the roll, or issue warnings for breaches relating to AML CFT obligations. And the court must determine the matters within 90 days, unless the delay is justified. And Clause 18 provides a right of appeal to the Court of Civil Appeal. Now, I have heard from certain quarters that this right of appeal to the Court of Civil Appeal is useless, since the matter is dealt with at first instance by the 2 judges. It is regrettable that such comments, devoid of any merit, I must say at the outset, have been aired without having properly consulted the Civil Appeal Act 2025, which specifically provides that the Court of Civil Appeal will consist of at least 2 judges, hence it can have more than 2 judges. And if I read section 11.2 of the Act, the Chief Justice may either proprio motu or an application in writing made to him by any party to an appeal, stating the reason for such application, direct that the case be heard by more than 2 judges, having regard to the magnitude of the interest at stake or the importance or intricacy of the questions of fact of law involved. Now, in such disciplinary matters since 1993 up to today, in most cases, in all the cases that we have seen, there have been at least 3, and in certain circumstances 5 judges that have been designated to hear such disciplinary matters at the Supreme Court. So let my friends who had qualms rest assured that this was looked at properly. There are a few proposed amendments that have been circulated this today, which I propose to move forward at committee stage in clauses 5, 9 and 20. Madam Speaker, the purpose of this bill is not punitive, but it is corrective. It strengthens the reputation of the profession by ensuring that complaints are handled fairly, independently and transparently. It protects the innocent by enabling frivolous complaints to be dismissed quickly, and it protects the public by ensuring that serious complaints are addressed with rigor. The professions themselves, Madam Speaker, in all our consultations, acknowledged that reform was needed. They too want clarity and consistency. They want a system that inspires public confidence, and they want unfounded allegations to be cleared without unnecessary delay. This bill achieves that balance. This reform also forms part of the wider transformation of our justice system. We have modernized appeals, judicial review, legal aid, and we continue to work towards a justice system that is accessible, modern, and humane. Public confidence is essential to that work. Citizens who entrust their liberty, their property, the fate of their families to a legal practitioner must feel secure. They must know that the system will protect them if something goes wrong. And conversely, a system that will also protect practitioners who face unjustified accusations. Fairness to all is the guiding principle. Madam Speaker, the legal profession is the backbone of justice. It is essential that it remain strong, respected, and trusted. This bill seeks to reinforce that trust. It is not a criticism of the many, but a safeguard against the few. It is an act of confidence in the profession and an affirmation of our duty to the public. I therefore, Madam Speaker, commend the bill to the House.
Yes, now it has to be seconded. Yes, Mr. Yutim, thank you. All right, so we're going to listen to Honourable Ramdas, and then we'll break.
Merci, merci Madame la Présidente. Madame la Présidente, d'abord permettez-moi de remercier et féliciter l'honorable Attorney General pour avoir présenté devant cette auguste Assemblée ce projet de loi, le Law Practitioners Disciplinary Proceedings Bill, un projet de loi, Madame la Présidente, qui a pour objectif la création d'une entité centralisée. Une entité, en fait, centralisée et chargée de traiter les doléances et les griefs formulés contre les praticiens du droit dans l'exercice de leurs fonctions. Et pour bien comprendre cette démarche, Madame la Présidente, il convient ici pour moi de rappeler que les praticiens du droit se retrouvent aujourd'hui à la croisée des chemins. En fait, au cœur même des interactions d'une part entre le citoyen et la réalité sociale dans laquelle il évolue de l'autre. L'avocat, en fait, Madame la Présidente, l'avocat est le professionnel visé par l'article 10 de la Constitution de notre pays, lequel article, en fait, garantit le droit à une représentation légale. Le droit à une représentation légale dans un procès au pénal, dans une poursuite, un procès au pénal. Et en ce qui s'agit, Madame la Présidente, des revendications relevant du droit civil, l'avoué, lui, représente le justiciable en quête de justice et d'équité, tandis que le notaire, lui, officier public habilité à dresser des actes authentiques, confère aux citoyens de ce pays, Madame la Présidente, des droits et obligations dans leur vie sociale. Ces praticiens, donc, ces praticiens du droit, constituent en fait des maillons essentiels de la mise en œuvre d'un aspect fondamental de la démocratie, de notre démocratie, celui de l'accès à la justice. Madame la Présidente, having said this, in fact, the nobility of the three branches of our legal profession, c'est-à-dire les avoués d'une part, les avocats et les notaires, in fact, the nobility of this profession stems from the crucial role which they are called upon to exercise in the administration of justice d'une part, et deuxièmement, from the stringent ethical standards to which they are subjected under their respective code of ethics, c'est-à-dire the code of ethics for barristers d'une part, the code of ethics for attorneys, et the code of ethics for notaries. However, we can only observe, Madam Speaker, regrettably so, that the existence of such rules do not, unfortunately, guarantee that all members of the legal profession will now toe the line and act in accordance with the principles that give to this profession its noble character. And given that any breach of the code of ethics by a legal practitioner is likely to have a direct and sometimes even a severe impact on the lay client's perspective, on the lay client's experience of the justice system, it's only then natural and indeed essential, Madam Speaker, that a stronger system of checks and balances be implemented once and for all. And whilst the Mauritius Bar Association, in fact, the MBA, the Law Society, the MLS, et la Chambre des notaires are already vested with investigative and disciplinary powers over their members as per the present law, the question now is whether the existing structures are still adapted to the realities of the profession and the realities of our society, Madam Speaker. Si nous prenons par exemple, Madame la Présidente, l'exemple de la Mauritius Bar Association. Le Bar Council, comme l'a dit l'Attorney General, le Bar Council est composé de 7 membres élus pour un mandat d'1 année. Et de ces 7 membres, 2 doivent être impérativement pourvus d'au moins 10 ans de pratique. Ce qui implique donc que les 5 membres restants peuvent avoir moins de 10 ans de pratique. Et nous le savons tous, Madame la Présidente, le barreau mauricien est de plus en plus jeune. Nous avons environ une centaine d'avocats qui prêtent serment chaque année. Et la proportion de nouveaux inscrits, de nouveaux avocats inscrits, en fait, augmente constamment. Et de ce fait, il ne serait pas surprenant et même peut-être un petit peu rafraîchissant d'un certain point de vue d'avoir un conseil, un Bar Council, majoritairement composé de jeunes avocats. Cependant, Madame la Présidente, bien qu'il soit une bonne chose que nous ayons de jeunes avocats sur le Bar Council, sur le Conseil, il serait quand même légitime de s'interroger quant à leur niveau d'exposition, quant à leur niveau d'expérience et surtout quant à leur niveau de maturité pour traiter de ces cas potentiels de manquement déontologique. And it's been a tradition at the bar, Madam Speaker, to resort to senior members for guidance on matters relating to ethics and etiquette. And in such a situation where the membership of the bar is increasingly comprising of members of the younger generations, it is certainly time to consider shifting investigative and disciplinary powers to a stronger body, a consolidated body, whose composition would reflect d'abord the seriousness of the task et bien sûr the solemnity of the mission conferred upon it. That is to probe into allegations, into breach of code of ethics and misconduct, and to determine, Madam Speaker, the consequences thereof. En dernier lieu, Madame la Présidente, it cannot be ignored that with the exponential, as I said before, with the exponential increase in the number of law practitioners, the number of complaints registered by the Bar Council on the one hand and the Mauritius Law Society on the other hand are also on the rise. And these bodies, Madam Speaker, are comprised of members elected on a periodical basis. I understand that it's 1 year for the Bar Council, and if I'm not mistaken, it's 2 years for the Law Society. And these officers, these members who are elected, they are elected to hold office on not on a full-time, on a part-time. It's not a full-time basis. Hence, the volume of complaints and the limited mandate of each body necessarily implies that there are practical issues in the timely disposal of any grievance formulated by members of the public, giving rise to frustrations and the perception of injustice when no comprehensive action follows from a complaint, or at least not in a timely manner. Donc, so much to say, Madame Speaker, que l'initiative de l'honorable Attorney General, en fait, arrive donc à point nommé. And obviously, if we go to the bill, Madam Speaker, I do not propose to go through all the clauses of the bill since the Honourable Attorney General has already done so, but I'll only address l'Assemblée on a few clauses. If we look at clauses 4 and 5, as regards the Complaints Commission, Madam Speaker, le projet de loi propose la création, sous la clause 4, d'une Complaints Commission, une commission composée d'un président, de 2 vice-présidents et de 9 membres. Et le président et les vice-présidents devront être respectivement un juge à la retraite, un ancien magistrat ayant servi au moins 15 ans, un avocat ou un law officer comptant au moins 15 ans de pratique. Donc une telle composition, Madame la Présidente, garantit que les plaintes portées devant la commission seront examinées par des professionnels aguerris, capables de comprendre les attentes du public, tout comme la réalité de la pratique de la profession légale. Autre clause, Madame la Présidente, celle de la clause 15, clause 15 qui parle du délai de 80 jours, comme nous l'a si bien dit l'honorable Attorney General. En fait, la clause 15.4 prévoit un délai de 90 jours pour que la Cour suprême statue sur toute procédure disciplinaire portée devant elle. Cela constitue, de mon point de vue, Madame la Présidente, une avancée majeure. Une avancée majeure puisque aucun délai n'existe actuellement sous les lois présentes. Et ce qui a conduit, le fait qu'il n'y a aucun délai sous les lois existantes, a conduit à ce que plusieurs affaires restent sans suite, minant ainsi la confiance du public. Et là, Madame la Présidente, je parle ici sous la correction de mes collègues avocats ici présents, dont vous-même, Madame la Présidente, qui se souviendront de plusieurs cas dont je ne citerai pas les noms ici, des cas de professional misconduct qui sont malheureusement restés impunis et sans aucune suite. J'en ai été témoin moi-même d'un gros cas de misconduct il y a plus d'une dizaine d'années de cela. Je ne citerai pas le nom, mais l'Attorney General saura de quoi je parle puisqu'il en a été témoin lui aussi. Madame la Présidente, je faillirai à mon devoir avant de terminer si je ne parle pas, par contre, d'un petit souci que j'ai par rapport à une petite incohérence, allons dire, par rapport à ce projet de loi. When I go through the bill, Madam Speaker, I note that it does not specify, I observe that it does not specify the burden of proof which rests upon the Complaints Commission when it prosecutes a case before the Supreme Court. And in fact, when we look at the bill, clause 17(1)(b)(3), la clause 17(1)(b)(3), Madame la Présidente, we note that the outcome of such proceedings before the court, the outcome of such proceedings may be as severe as the erasure of the name of a law practitioner from the roll. This is indeed very extreme, Madam Speaker. It's indeed a very extreme measure, la radiation complète d'un avocat, d'un avoué ou d'un notaire. Je ne suis pas contre. Mais par contre, puisqu'il y va du livelihood, puisqu'il y va du livelihood du praticien, would it not be appropriate, Madam Speaker, to specify in the bill that the burden of proof should be beyond reasonable doubt? Beyond reasonable doubt, or at least a higher burden than that of the civil burden of proof, which is on the balance of probabilities. I'm saying this, Madam Speaker, of course, since the erasure of a professional, of a barrister, a notary, or an attorney from the roll, in fact, goes to the very ability of that law practitioner to earn a livelihood, and this should not, therefore, be taken lightly. Madame la Présidente, en guise de conclusion, in fact, it is true to say that this bill addresses many of the shortcomings in the existing structures. In fact, it enhances the process in a bid to hold accountable those law practitioners which disregard completely the letter and the spirit of the Code of Ethics. Et ce projet de loi, Madame la Présidente, aura pour vocation de rendre à la profession légale ses lettres de noblesse, puisque trop longtemps, Madame la Présidente, les valeurs de cette profession ont été effritées par les agissements de certains, des agissements impunis, des agissements sans qu'aucune sanction ne soit prise contre ces brebis galeuses de la profession qui ternissent malheureusement la réputation de tous les avocats. Merci, Madame la Présidente.
Merci. Sur ce, nous allons prendre un peu de thé.
Speaker.
Please be seated. Yes, Honourable Levin.
Thank you, Madam Speaker. Madam Speaker, I wish to commend the Attorney General for bringing such an important reform before this House. The objective is clear and commendable, that is to modernize our disciplinary architecture for the legal profession, provide procedural clarity, and enhance public trust in the administration of justice. And as the Honourable Attorney General rightly pointed out, there was a first draft, then there was consultations with the Bar Council, with the Law Society, with the Chambers of Notaries, and there were several proposals made. And as lawyers, we are glad that there has been a consensus and we are here before this House with a very comprehensive and well-drafted piece of legislation. Madam Speaker, this effort deserves recognition because it is taking us back to 1998, whereby there was a presidential commission appointed Lord Mackay of Clashfern to prepare a comprehensive report with regard to reform of the judicial and legal system and also the legal profession, to have a look at the legal profession. So way back when there was the Labour-led government in 1998 with the then Prime Minister, the current Prime Minister, Dr. Ram Ghulam, that reform was on the agenda. And I'm glad today that we are continuing in this process to have access to justice. And if I'm not mistaken, it's maybe the 27th or 28th bill of the Attorney General before this House to enhance access to justice with such a comprehensive piece of legislation again. Madam Speaker, the major change, the fundamental change being brought through this bill is the full centralization of disciplinary intake and investigation. Honourable Ramdas spoke about Clause 4, whereby the establishment of the Practitioners' Complaints Commission and also complemented by Clause 8, subsection 2, with regard to any complaint addressed to the Bar Council, to the Mauritius Law Society, to the Chamber of Notaries, or even the Attorney General, must be promptly referred to the Commission. In the legal profession, Madam Speaker, there are a few that apprehend this piece of legislation. They thought that this is a radical shift or change from what we are used to, that is self-regulation. But I would like to take a few examples so that our fellow lawyers will understand that the trend is for reform. And this is being done in many Commonwealth countries. So this is not a radical proposition. This is in line with what many Commonwealth countries have been doing for years now. We take the example of Australia, Madam Speaker. Each state and territory has a Legal Services Commission. These are statutory bodies completely independent from bar associations. Their mandate is to investigate, mediate, and if necessary, prosecute legal misconduct before independent tribunals. In the same vein, Madam Speaker, in New Zealand, they have got the Lawyers and Conveyancers Act of 2006, created a single entry complaints service managed by the New Zealand Law Society, but decisions are reviewable by the Legal Complaints Review Office, an entirely separate and impartial body. In South Africa, Madam Speaker, they took the bold step through the Legal Practice Act 2014, which established the Legal Practice Council, a unified regulatory authority overseeing all legal practitioners. It ensures that the public can lodge complaints in a transparent and efficient manner. Even in Canada, Madam Speaker, in Ontario, the Law Society functions as both a regulator and a complaint handler, but decisions are made by disciplinary tribunals with strict rules of independence and lay participation. So this is not something out of the blue. This is the trend with regards to the modernity that we are bringing in the legal profession. The Honourable Attorney General pointed out we've got more than 1,600 lawyers now. And Honourable Ramdas, he's not here, has been saying that he's here. Oh, okay, yes. Okay. So around 100 lawyers are being called to the bar almost every year in Mauritius. So the legal profession is a blend of old, new, and newcomers with speciality in very specific fields.
It was 50 when I started.
50. Okay. 50.
Yes, only 50.
So all these, Madam Speaker, bring us to what we need, reform. And this piece of legislation, well drafted, is part of this process of access to justice. And, Madam Speaker, there is a very important clause that I would refer to. I will not be repetitive to what Honourable Ramdas and the Honourable Attorney General said, but I would like to specify on clause 9 of the bill. It empowers the Commission to dismiss complaints that are frivolous, trivial, and vexatious. This is an essential filter because, Madam Speaker, unfortunately in Mauritius, we've got a few jack of all trade and master of none. They know the profession more than others, and there are so many adverse comments because they do not know how the profession functions. For example, you take the cab rank rule. For many people, they do not know the basics of this important rule because this is for lawyers, and I must admit that at the level of the bar, we need to disseminate, we need to educate, and we need to give proper guidance as to how our profession is all about. So this important filter is something that is very commendable, and this is also mentioned in clause 8, subsection 2, whereby all complaints would be now directed to the Commission. Now, what are the risks, the practical issues? The practical issues is the Commission may risk becoming administratively overburdened. Why I say so, Madam Speaker, is that this practical issue is already well documented internationally. A significant proportion of complaints received by legal regulators worldwide relate to delays, communication issues, or fee disputes, none of which constitute misconduct. That is why I would here make a proposal. There is in the United Kingdom the legal ombudsman. I will call it the legal ombudsperson. So over there in the United Kingdom, Madam Speaker, service quality complaints are handled by the legal ombudsman, allowing disciplinary bodies to focus solely on allegations of ethical or professional breaches. Similarly, New Zealand, Madam Speaker, separates preliminary assessment and service complaints from serious disciplinary matters through the Lawyers' Complaints Service. Introducing a similar mechanism here, whether now or at a later subsequent phase, could greatly enhance the efficiency and clarity of the system. And why I say so, Madam Speaker, with the establishment of a legal ombudsperson, this would bring three major benefits. It would firstly educate the public about the distinction between misconduct and service complaints. It would also filter out non-disciplinary matters, ensuring the Commission's resources are used appropriately. And thirdly, to protect the Commission from becoming overwhelmed, allowing it to concentrate on serious misconduct as intended by this bill. The Commission's mandate, Madam Speaker, as structured under Clause 8 to Clause 14, is to assess professional misconduct. a complementary mechanism to deal with service issues would ensure disciplinary system remains accessible, efficient, and fair. So this is the proposal I'm making to the Honourable Attorney General, and this goes in line with what we call the Commonwealth Latimer House principles. These are guidelines with regards to promoting good governance, democracy, but also rule of law, access to justice, and most importantly, the independence of the legal profession. And in this vein, I would humbly invite the Honourable Attorney General to consider this suggestion offered in a spirit of constructive reflection, because I do not want to detract from the merit of this bill. Rather, the aim is to reinforce effectiveness with regards to a balanced, independent, efficient, and capable of maintaining public trust in this new commission. Because at the end of the day, Madam Speaker, this law practitioners' disciplinary proceedings bill is a serious and thoughtful reform that aims to strengthen transparency and also to give confidence to the public at large that the legal profession is here to participate in this administration of justice. So I would invite the Honourable Attorney General to kindly consider whether maybe at a later stage we could implement this legal ombudsperson so that we can filter and also disseminate what we could qualify as misconduct or, again, other complaints that could be dealt at administrative level. So this is my participation in this debate, Madam Speaker. I thank you for your kind attention.
Thank you. Honourable Minister.
Madam Speaker, 32 years ago, on a cold evening on the 25th of November 1993, I was called to the outer bar of the Society of Middle Temple. Incidentally, on this very same day, at the very same time, our Honourable Prime Minister was being called at the Inner Temple. In England, every barrister has to be a member of a professional association known as an Inns of Court. We have Lincoln's Inn, Gray's Inn, Inner Temple, and Middle Temple. But what surprised me when I was admitted to the bar is that each of these associations carries the name Honourable Society. So when you are called to the bar, you become a member of the Honourable Society of one of the Inns of Court. Why? Because barristers, as is set out in the very first paragraph of our Code of Conduct, Code of Ethics for barristers, and I quote, honesty, integrity, independence, and strict compliance with professional standards remain constant requirements for all those who seek to practice at the bar. Unfortunately, Madam Speaker, not all practitioners today adhere to these ethical principles. Most of us do, but not all of us. And this bill is providing the necessary legal framework for law practitioners to be held accountable for their action and be subject to disciplinary proceedings where necessary sanctions. So as of today, there are two separate and distinct mechanisms to deal with cases of breach of etiquette, breach of professional misconduct involving a law practitioner. And by law practitioner, I mean barrister, attorney at law, and notary public. First is by self-regulation. So the professional bodies of which the law practitioner is a member takes the sanction. The Bar Council, the Mauritius Law Society Council, or the chambers of notaries have the discretion to investigate and any report made to it regarding alleged act of professional misconduct. The professional bodies can then reprimand or severely reprimand a law practitioner. However, they are required by law, and that is very important, to attempt to reach an amicable settlement, an amicable solution, and afford the law practitioner with an opportunity to be heard. Only where after preliminary investigation there is a prima facie case of serious professional misconduct that the professional body refers the matter to the Supreme Court for determination. So that is the first general mechanism. The second mechanism to investigate and institute disciplinary proceedings against a law practitioner rests with the attorney, the Honourable Attorney General. The Attorney General has the power under the Law Practitioners Act, either on his own initiative, propriu motu, or on receipt of a complaint to inquire into any act done by a law practitioner. Where the Attorney General is of opinion that the act done by a law practitioner calls for the institution of disciplinary proceedings, he has to submit a detailed report to the Chief Justice, who then proceeds to hear the matter. So first, there is CF regulation. Second, there is the Attorney General who refers the matter to the Supreme Court. And then, thirdly, there is the Supreme Court itself, under its inherent jurisdiction. It has the power to hear and determine any complaint against a law practitioner under Section 18 of the Courts Act. But as at today, and this is not going to change with this new bill, it is only the Supreme Court that has the power to order that the name of a law practitioner be erased from the roll so that he can stop practicing. And I pose here to reconfort the Honourable Ashley Ramdas that the Supreme Court always acts reasonably when imposing the sanction. In the case of Babulal, for example, the Supreme Court held that the case will be visited by a suspension of 1 year. So they gave a suspension of 1 year. However, since it was the very first case of disciplinary proceeding for such professional misconduct, which did not involve dishonesty, that was a client, the court said that they were prepared to suspend the decision to suspend for a period of 3 years. So the Supreme Court is not going to lightly suspend a law practitioner or remove him from the role. But, Madam Speaker, in practice, and this is, I totally confer with the Honourable Attorney General, the system is not seen to be working. The Supreme Court is rarely called upon to determine allegations of professional misconduct against law practitioners. I have gone through all the law reports. In the past 25 years, there are only 7 reported cases where disciplinary proceedings against law practitioners have been brought before the Supreme Court. 2 barristers and 1 attorney had their names removed from the roll of practicing law practitioners, and 1 barrister was suspended for a period of 6 months. Why? Is it because all practitioners are adhering to their code of ethics? Rather, there is a perception, Madam Speaker, that the current mechanism of disciplinary action against law practitioners is not working. Professional bodies, be it Bar Council, the Law Society Council, the Chambers of Notaries, hardly ever report a matter to the Supreme Court for disciplinary proceedings. There is this perception of lawyers sticking together. You know, you scratch my back, I scratch yours. True it is that the law as currently stands gives the power for them to attempt an applicable solution. Le linge sale, après tout, se lave en famille, Madame la Présidente. But the law also requires them to refer cases to the Supreme Court whenever there is a prima facie serious breach of code of ethics. And I will give you an example, Madam Speaker, to illustrate my point. And this is within the public domain and concern the Honourable, this August Assembly, because it was a subject of a PNQ last year on the 12th of June 2024. It concerned the conduct of the then Minister of Environment, Mr. Kavidas Ramano. It was established that whilst Mr. Ramano was Minister of Environment, an application was received at his Ministry of Environment for an environment impact assessment. And the application was supported by a certificate, a document under the letterhead of Études Ramano, signed for Monsieur Kavidas Ramano. There was a clear conflict of interest. You cannot be a minister, be called upon to determine an EIA application, and your own personal notarial practice, l'étude, is signing a letter confirming the ownership of the land subject matter of the EIA application. The more so when the certificate is signed by an employee of that notary public. And according to the reply, the application was made on the 8th of May 2024. That is more than 4.5 years after Mr. Ramano had been a minister. So he can't come and say that these are work that I was doing before becoming minister. So 4.5 years later, his etude, of which he was the full owner, was still operating and issuing applications which were considered by his ministry. Was that normal? Was that ethical? Yet, the chambers of notary refrained to comment. And in a communiqué, they stated, and I quote, cette situation pourrait faire l'objet d'enquêtes et par conséquent, la Chambre se voit contrainte de ne faire aucun commentaire sur cette affaire spécifique. What happened since? Where is the Chamber of Notaries? Have they conducted an investigation? Have they taken sanction? Have they referred the matter to the Supreme Court? Another example, the case of another notary public, Mr. Vinay Dilchan. There were endless complaints of the public concerning his failure to comply with his statutory duties. In September 2024, the Supreme Court even ordered him, together with another defendant, to pay the sum of 2 million rupees to a plaintiff concerning a fictitious sale. Yet, have you ever heard the Honourable, les notables, members of the Chambers of Notaries referring a case of Mr. Dilchan to the Supreme Court for disciplinary action? And the list is long, Madam Speaker. Now, what about the Attorney General? The Honourable Attorney General, I call him the double Honourable. Honourable member of an Inn of Court and an Honourable member of Parliament. I'm taking exception to the Honourable incumbent. From 2007 to 2009, there were a few cases where the Attorney General had reported to the Chief Justice cases for disciplinary proceedings, and mostly were following conviction in criminal cases. But no disciplinary proceedings seem to have been reported since 2014 by the then Attorney General. And that's probably, Madam Speaker, because according to their personal ethical standard, there were no professional misconduct. May I remind you who were those Attorney General? The Honourable Yerigadou, l'homme aux honoraires de 32 millions, the minister who was forced to resign over the Bet 65 scandal. Who was the other Attorney General? Honourable Manish Gobin, currently on bail for the offence of public official using office for gratification under in breach of Section 7.1 of the Prevention of Corruption Act. Not so honourable after all. The problem, Madam Speaker, when you give the power to the Attorney General to initiate or not to initiate disciplinary proceedings before the Supreme Court is that you're effectively giving the power to a politician, no offense again intended to the present incumbent, but you're giving power to a politician to use this power to persecute a political opponent or use that power to protect his political allies. That is the problem with the current system. In June 2018, the Commission of Inquiry on Drug Trafficking in Mauritius, chaired by the former Justice Lam Sham Ling, published its report. It sent shivers up and down the spine of law practitioners. It uncovered a fine-tuned system where certain law practitioners seem to be acting as accomplices for drug traffickers. To cite an extract of the report at paragraph 19.5.3, and that paragraph has not been expunged by any order of the court. It's worth listening, Madam Speaker. The Commission has a very strong reason, in the light of the evidence adduced before it, to believe that there is a handful of barristers who may have acted and may still be acting in a most unethical manner, if not engaging in illicit activities such as obstructing the course of justice, intimidating witnesses, causing witnesses to diverge from their original statement version, thereby abstaining from incriminating certain drug barons. Likely to have been not, but they were also likely to have been using drug money to finance political campaigns, possibly money laundering the proceeds of drug trafficking in accepting willfully tainted money, accepting cash beyond permissible amount, and not accounting same in their VAT receipt, and generally fostering incestuous relationship with drug tycoons. And who were those law practitioners cited in the report? Who were the brebis galeuses? Most, if not, were from the MSM party, Madam Speaker. As the Honourable Prime Minister said, à la prison, unsolicited visit to prisoners, mobile phone communication with drug lords serving their sentence in prison. And let me clear something, because in the case of the Honourable Rubina Diadou, she was a minister, so it's directly relevant to this House. She had to resign after her name was cited in the report, and she went to the Supreme Court and asked a judicial review of the finding of the Commission. And on two counts, complaint, namely the phone communication with prisoners and the unsolicited visit, the Supreme Court found no merit in her complaints and held that the decision of the Commission of Inquiry was not manifestly unreasonable or irrational. And what happened? Instead of the Attorney General initiating an inquiry against the lady, the MSM gave her a ticket to run as candidate at constituency number 2 in the election of 2024. Luckily, the electorate, like all of them, threw them out of history. So, Madam Speaker, we can see even under the self-regulation or under the existing Attorney General, it's not working. Legal proceedings, disciplinary proceedings are not being brought against law practitioners. Now, this will change with this bill. So with this bill, we will no longer have self-disciplinary action by the association, the professional association, the Bar Council, the Law Society Council, the Chambers Notary, and no more any power to the Attorney General to decide whether to institute legal proceeding or not. Instead, we are replacing it by a new independent law practitioner complaints commission, which will be an independent body, and it will be under the direction of control of no person or authority. What is interesting, Madam Speaker, with this body, the Attorney General will not sit on any of the inquiries. In fact, there will be a chairperson or a vice chairperson and 2 members of the relevant profession. If there's inquiry over the conduct of a barrister, there will be 2 barristers sitting on the committee. If there's inquiry over an attorney, there will be 2 members of the Law Society. If there's inquiry over the conduct of a public notary, you will have 2 public notaries. What is also a very important departure from the existing law is today professional misconduct has been defined widely. It does not cover only breaches of the Code of Ethics, but also covers improper, disgraceful, dishonorable, or unworthy act that has brought his profession or her profession or the administration of justice into disrepute. So that goes wider to just the black letter of the Code of Ethics and also goes in his personal life, the way he has behaved in public, whether that has brought the profession in disrepute. The bill, as the Honourable Attorney General mentioned, has now a set deadline, 6 months to report the complaint and 90 days to complete the inquiry. This is most welcome because for those law practitioners who wants to clear their names, it is very important that there is a set time frame to do so. Another important change, the disciplinary proceedings will now be heard in front of a bench consisting of 2 judges, and the aggrieved party can appeal to the Court of Civil Appeal. This is a major difference from the current practice where disciplinary hearings are heard before 3 judges and the appeal is to the Judicial Committee of the Privy Council. Madam Speaker, the legal profession of which I am a part of is in its very essence a very noble profession. And it goes, or at least should go, without saying that those admitted to this profession must uphold the highest ethical standards and a top-notch professional conduct. Regrettably, even in the most respected profession, there are a few whose conduct tarnishes the reputation of the many. This bill is not just a legislative reform, but a structural safeguard for the rule of law, for fairness, and for equal accountability, whether the lawyer is well connected or not. Thank you.
Thank you, Mr. Honourable Attorney General. I know you don't like me saying winding up speech. I just checked. It's perfect English. But I will ask you to round up.
Madam Speaker, there is a well-known line from Shakespeare that is often quoted. And let me hasten to add that before I actually spell out the words, that I do not approve, of course, of its contents. It's spoken not by reformers in the play Henry VI, but by those plotting to destroy the rule of law. And it goes as follows. The first thing we do, let's kill all the lawyers. The meaning is very simple. If you wish to collapse a society, you begin by silencing those who know the law, who defend rights, who safeguard due process. Far from being an insult to the profession, the line just quoted is just a reminder of the centrality of lawyers in any functioning democracy. Madam Speaker, this is why the bill before the House today matters. It recognizes that the strength of a democracy is tied to the strength of those who serve justice, and it recognizes that confidence, public confidence, is the bedrock on which the legal profession must stand. If at this stage I could respond to my learned friends who have addressed the House today. To the Honourable Ramdas, I will draw attention to the fact that Section 15, subsection 2c, clearly spells out that the disciplinary proceedings before the Supreme Court shall be conducted in the same manner as proceedings in a civil matter. And of course, that is on a balance of probabilities. The suggestion that lawyers should be treated differently from any other professional being placed before a disciplinary committee under the Workers' Rights Act would not sound very good. If it's good for everyone else, it should be good enough for us. As far as my learned friend Lubin, Honourable Lubin's comments are concerned, I take on board the suggestion of the complementary mechanism of the legal ombudsperson, but I do think that at this stage, and I take his point, that we should perhaps look at this in the future, if ever we have this administrative overburden on the system. For my friend, on the part of Honourable Utim, let me say that I have nothing to add. The vast majority of our attorneys, barristers and notaries, Madam Speaker, serve with dignity and competence, but we must acknowledge an uncomfortable truth. Confidence has been shaken, not because the profession is corrupt, because the system for dealing with a few cases of misconduct has not kept pace with modern expectations. The bill is not a reprimand to the profession. It is an act of respect, an act of commitment, an act of confidence. It says clearly, your honour matters, your role matters, your credibility matters, and we will help you protect it with a system that works, that is transparent and independent. Our government, Madam Speaker, has promised to renew the foundations of our institutions, We have said that democracy must be strengthened not only in its ground principles, but in its everyday workings. A justice system cannot be credible if citizens doubt whether misconduct in the legal profession is treated impartially. Nor can it inspire confidence if lawyers themselves feel that well-intentioned colleagues are tarnished by the acts of a few. The bill answers those concerns with balance and clarity. Madam Speaker, a society that values the rule of law must also value those who practice it, and valuing them means helping them uphold the highest standards. That is what this bill does. It protects the many from being stained by the few. It protects citizens who seek justice, and it protects the integrity of the three professions, and that is indispensable to the health of our democracy. I thus commend the bill to the House.
Thank you. So the question is that the Law Practitioners' Disciplinary Proceedings Bill be read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
Committee stage.
Oui, the amended. Yes, you may be seated.
Clause 1, short title. Clause 2, interpretation. Clause 3, non-application of act. Clause 4, establishment of complaints commission.
One moment. The question is that Clause 1 stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Qu'est-ce qui s'est passé? Clause 2. This is the amendment, right? I'm sorry. It's not as simple as in court. What I have here, I have to move that Clause 2 be amended. No?
No, just give me a second.
Il y a un problème, hein? Excusez-moi.
Madam Speaker,
Yes.
the First Amendment is at Clause 5, so 1, 2, 3 and 4 should
Yes,
go
all
without
right.
amendments.
So this is no good. Okay, let me just say, and then you'll tell me. The question is that Clause, I've already said 1. Now Clause 2, 3 and 4 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Now we go to Clause 5.
Clause 5, compulsion of complaints commission.
Madam Speaker, I move that Clause 5 of the bill be amended as per amendments circulated today.
The question is Clause 5.
Okay. The question is that Clause 5 be amended. Vous n'avez pas l'amendement?
Yes.
We should have.
Yes. Just put the question that the Clause 5 be amended as per amendment circulated.
Okay. The question is that Clause 5 be amended as per the amendment circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. That was Clause 5. Attends, maintenant, on va faire... Non, celui-là, c'est Smaffer. I'm going to do it by myself. The question is now that clauses 6 to 8 stand part of the bill. Those in favour say aye. Those against say no. I didn't hear any. The ayes have it. I know it's late, not that late. 9.
Clause 9.
Now there's an amendment.
Madam Speaker, I move that Clause 9 of the bill be amended as per the amendments circulated today.
Question is that clause 9 be amended as per amendment circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. Il n'y a personne. Bon. The question is that clause 9 as amended stands part of the bill. Those in favour say aye. Those against say no. Aye. The ayes have it. For clause 5, we didn't do that part. I'm sorry. I'm going back for clause 5. I have to go back for clause 5, just to make sure that we're doing it the right way. The question was that clause 5 as amended stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. C'est juste qu'on n'a pas fait les deux morceaux. Vous avez l'habitude maintenant. Moi aussi, mais bon.
Clause 10, conciliation by Complaints Commission. Clause 11, investigation by Complaints Commission. Clause 12, caution by Complaints Commission. Clause 13, no evidence of professional misconduct. Clause 14, institution of disciplinary proceedings. Clause 15, inherent powers of Supreme Court. Clause 16, interim order of Supreme Court. Clause 17, disciplinary powers of Supreme Court. Clause 18, appeal. Clause 19, protection from liability.
Okay. Now the question is that clauses 10 to 19 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 20, consequential amendments.
Madam Speaker, I move that clause 20 of the bill be amended as per the amendment circulated today.
Okay. Question is that clause 20 be amended as per amendment circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. Question is that clause 20, it's always en deux morceaux. So now the question is that clause 20, as amended, stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 21, transitional provisions. Clause 22, commencement.
That was 21 and 22. The question is that clauses 21 and 22 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
30, enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Now the question is that I do report to the House that the Law Practitioners Disciplinary Proceedings Bill number 29 of 2025 has passed the committee stage with amendments. Those in favour say aye. Aye. Those against say no. The ayes have it. Thank you. Sorry for the capital. One moment, you may be seated. Alors, je dois me retrouver. Okay. Honourable members, I have to report to the House that the Law Practitioners Disciplinary Proceedings Bill number 29 of 2025 has passed the committee stage with amendments.
Third reading.
I move that the Legal Practitioners Disciplinary Proceedings Bill number 29 of 2025 be read a third time and passed.
It's seconded? Yes? Question is that the Law Practitioner Disciplinary Proceedings Bill number 29 of 2025 be read the third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Prime Minister, adjournment.
Madam Speaker, I beg to move that for the adjournment of the House to Tuesday, the 9th of December at 11:30 a.m.
The question is that the House be adjourned to Tuesday, the 9th of December at 11:30 a.m. Those in favour say aye. Aye. Those against say no. The ayes have it, and the House stands adjourned.